down. But our broadcast is ready. So I'll declare open the public hearing of the Standing Committee on Social Policy and Legal Affairs inquiry into family violence orders. I'd like to acknowledge the traditional custodians of the country on which we meet today and pay my respect to their ancestors and elders, past, present and emerging. And I extend this respect to all Aboriginal and Torres Strait Islander peoples and their cultural and spiritual connections to Australia's lands and waters. This hearing is being broadcast and the transcript of proceedings will be published on the Parliament's website. I invite members of the committee to introduce themselves. Well, I will first introduce myself, Susan Templeman, member for Macquarie and Special Envoy for the Arts and Chair of this committee, and might go to my Deputy Chair.
Thank you, Chair. Pat Conahan, member for Cowper, Shadow Assistant Minister for Prevention of Family Violence and Social Services.
Kate, do you want to do a proper?
Yes, hello. I'm Kate Chaney, Independent Member for Curtin in Western Australia.
And Mr Newman?
Shane Newman, Federal Member for Blair, Labor MP, based in Ipswich in South East Queensland.
Louise Miller-Frost, I'm the Labor Member for Boothby in Metropolitan South Australia.
Thank you. We may be joined by additional committee members as the hearings continue. I now welcome representatives of the Australian Institute of Family Studies to give evidence this morning. For the Hansard record, would you please state your name in full and the capacity in which you appear before the committee? And I'll leave it to you to decide who goes first.
Good morning, all. Thank you for inviting us to appear this morning. My name is Kira Duggan. I am the Research Director of Systems and Services in the Australian Institute of Family Studies, which houses the family law research team, whose leader I'll throw to now. Thanks, Rach.
Thank you very much. Good morning, everyone. My name is Dr. Rachel Carson and I'm the Executive Manager of the Family Law, Family Violence and Elder Abuse Research Team at the Australian Institute of Family Studies.
Thank you. Although you're not required to give evidence under oath, this hearing is a legal proceeding of the Parliament and it has the same standing as proceedings of the House. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Do you wish to make a brief opening statement before we proceed to discussion?
Thank you. I'll make a quick opening statement on behalf of the Australian Institute of Family Studies, just to provide the committee with a quick overview that we are a Melbourne-based Australian government statutory agency established in 1980 under the Family Law Act of 1975, and our mission is to conduct high-quality, impartial research into the wellbeing of Australian families, to inform policy and promote evidence-based practice in the family services sector. Since our inception, AFS has conducted research relevant to the factors affecting family stability in Australia, with research on separating and separated families, family law and family violence, which is critical to this core function. Our submission to you presents findings that are predominantly based from a great body of AFS research into these areas over a number of years, with references to other relevant research relevant to the committee's terms of reference for this inquiry. You will note that our submission presents research findings regarding the nature and experience of family violence by parties who are separating or have separated, including those engaged in family law proceedings relevant to terms of reference. Point number one, we talk about the process to obtain and enforce family violence orders by litigants in the family violence system, including in relation to barriers or challenges, terms of reference area number two. And finally, a discussion of the improvements to support the accessibility of family violence orders and safety and fairness for people requiring so, against terms of reference 3 and 4. Thank you very much.
Thank you. Well, look, I might start the discussion. You've just said you've conducted a significant amount of research, and we're particularly interested in the prevalence of family violence in the families who do appear before the Federal Circuit and Family Court of Australia. So what can you tell us about your overarching findings of research within that sphere?
If it's okay, I might answer that question. So in the space of family law in particular, we've undertaken a number of evaluations of successive reforms to the Family Law Act. In the most recent large-scale evaluation of separating families, we found that a very substantial proportion of families who are separating do report experiencing family violence, both before and during their separation and subsequent to their separation. The Experiences of Separated Families study showed that 58% of families reported that they were experiencing that form of violence as they were separating and prior to separation, and that for a substantial proportion of families that does continue post-separation. So 45% of participants in our Experiences of Separated Families study reported that they experienced that violence since separation. Critical also that we identified from our research at the same time with these participants in the Experiences of Separated Parents study, which the most recent cohort in 2014 had over 6,000 people participating, was as the formality of the interventions that those families engaged with increased, so increasing, for example, from family dispute resolution through to engaging a lawyer and then undertaking court proceedings, so too does the complexity of those families and their reported experience of family violence. In our submission, you'll note that we extracted a table from that particular report, and I could direct you to that table. In Table 1 in our report on page 3 of our submission demonstrates that as those parties, the formality of their engagement with court processes, legal processes increases, you'll see that so too does their reports of experiencing emotional abuse and physical abuse. So, for example, taking physical abuse, approximately 27% of families or participants in the Experiences of Separated Parents study indicated that they were experiencing physical abuse. That increases to about 39% when they're engaging with lawyers, and that increases again to 38% when they're engaging with courts. The complexity of these families also increases, where they are indicating that they are experiencing multiple co-occurring issues, and that rises as the formality increases, as does their reports of current safety concerns also. So that's quite an important factor to keep in mind, and is supported by the Federal Circuit and Family Court's own data from their Lighthouse risk assessment project. When we think about those even more complex families that are engaging with the court system, so those that have repeated engagement with the system, including through the contravention court process, we see these characteristics emphasised in a particular way. So they're particularly complex families that are engaging with the courts repeatedly. So we see these features that I've described of high reports of the range of complex risk issues that face families, particularly prominent for those who are experiencing repeated engagement with the court system.
In that context, you're talking about when there's there are compliance issues, and so there's things happening on both sides. So, is it possible just to talk about those compliance issues? Is there any other?
Yes.
Can you tell us a bit more detail about what is going on and where the violence,
of course,
is occurring?
Yes. So in those particular cases where there are issues with compliance, we see that family violence and interpersonal dynamics, and those challenges with interpersonal dynamics are particularly prominent. We see that, for example, in the way in which these cases present at court, they're often engaged in proceedings over very protracted periods of time. 30% of matters are engaged in that particular subset of family law cases are engaged over a period of 5 to 9 years with the court system. And a small but not insubstantial proportion, 6%, were engaged with the court for 12 years and over. So very significant proportions of children's lives are engaged with these proceedings. 1/3 of the sample in our compliance with an enforcement of family law parenting orders project had multiple contravention applications. Nearly 6 in 10 of those involved 5 or more court applications, and on average, there were 6 court processes for each of the matters that were included in our sample. So we can see there that there's very significant complexity in these particular matters. That's borne out in terms of the rates at which we observed from the court files in these matters that there were allegations or evidence on file in relation to the range of high-risk issues, including domestic and family violence. So, for example, it was most common for evidence of allegations to be raised in both the primary parenting proceedings and then also in the subsequent contravention applications. So more than half of the sample in the contravention cases involved allegations of family violence in those primary parenting proceedings. And then when there were the subsequent contravention allegations, or issues rather, I should say, that also involved a sizable proportion of matters where family and domestic violence were raised as well. Are there particular issues about those contravention cases that you'd like me to talk more about? For example, the research that we undertook was both quantitative and qualitative, and we did identify that from both the quantitative and qualitative data that there were complex interpersonal dynamics that were at play in the process of these contravention proceedings. There were concerns, for example, that the proceedings were being used as a means by which to continue to perpetrate the domestic and family violence that had preceded the relationship or preceded the court proceedings and characterised the relationship, I should say. The qualitative data provided particular insight as well, because when asked about the particular dynamics of these matters, professionals, including judicial officers and lawyers, but also parents who were participating in our survey data, talked about how there was intractable conflict and mistrust between the parties. There was abusive and controlling behaviour that was being borne out in the proceedings. There was an unwillingness on the part of parties to support the relationship between the child and the other parent, and to not behave in a child-focused way. These are very significant characteristics that characterise the experiences of these families, not only during the separation process, but also subsequently. And so support is required to assist these families to address those underlying issues and to address the family violence so that they can proceed in a healthy and child-focused way going forward.
Thank you. Thank you for that very comprehensive insight into it. I'm going to hand to the Deputy Chair and then I'll come to Mr Newman after that, just so you know your order, and then Ms Chaney, and then we'll come back to you.
Thank you, Chair. Thank you, Dr Carson. I'm really interested in the graph or the table that you pointed out on page 3, particularly in relation to the emotional abuse and the physical violence that you spoke about. Firstly, this table is from 2014. Do you know if there's more recent research and statistics Because there has been quite a deal of improvements in the family law system over the past decade.
Absolutely, absolutely. And that was one of the reasons why I was referring to the court's Lighthouse project.
Yep.
The Lighthouse project that the court has implemented supports risk assessment and triage through their court system. Unfortunately, it does reflect that there are very significant continuation of these complexities in the families that are engaging in the system. We see that the most complex of families are turning to and need the support of the court to resolve their issues. At the Institute, our most recent data is the data that relates to those most difficult of cases, the contravention cases that I spoke about, but we don't have the large-scale representative samples more recent to this data. This is the most recent data that we have of a representative nature.
So with less complex cases, it would be fair to say that diversionary procedures or process without involving the family law court and lawyers would be the best practice.
Yes, court, even when there are not these issues of significant complexity and these problematic dynamics in families, even in those instances, engaging in legal processes are very stressful and can be traumatic for people. So yes, where possible, it's better to support families to resolve their matters outside of the court system, but that's not always possible, unfortunately, particularly where families are in quite intractable circumstances or where there are particularly high risks that need to be assessed and families supported to identify the most appropriate and safe arrangements going forward.
Has your organisation looked into the success or otherwise of mediation? We've seen a lot of an increase in mediation through the family law court over the past 5 years. Has that seen more success? I mean, that jump from 26.6% to nearly 39%. I mean, that's alarming, just by engaging a lawyer.
Well, yes, and that's not to say that those families who engage with family dispute resolution aren't characterised by these high risk issues, as you can see from the table. They certainly are, but the most recent data that we do have in terms of parents' reports of their satisfaction of engaging in services, which is at the time of this particular survey, the Experiences of Separated Parents study, that does indicate significant satisfaction and indeed parents identifying this as their preferred course of action through FDR, family dispute resolution. That reflects in part the capacity of the family dispute resolution system. It also reflects the fact that parents value the opportunity to come to an agreement themselves rather than having a decision imposed on them. But high levels of satisfaction from parents who reported that they had used family dispute resolution as their main form of dispute resolution, as the main source in which they resolve their parenting matters. There were high rates of satisfaction from parents exercising that course of action, yes.
Are there any other changes in the family law system that you've seen in recent months or years that you thought have been successful or your research has shown have been successful?
Yes, there are a range of very important measures that have taken place in recent times. The Court's own Lighthouse program that I mentioned before is a very significant development because it ensures that we are better able to identify and then assess and respond to domestic and family violence and other risk issues as they emerge in court and matters when they proceed to court. That's been critical in supporting the court system to address those particular issues because prior to the introduction of that particular risk assessment measure, our experiences of separated parent studies showed that nearly 30% of parents who were responding indicated that they had not been asked about whether there were domestic and family violence or child safety concerns. So the introduction of this risk assessment model through the court is critical to ensuring that we are asking the right questions. In addition to the Lighthouse model, there's been a very important measure in terms of the co-location of relevant services, including police and child safety practitioners in the court to support the identification and response to these risk issues, and to support families engaging in the court while they're characterised by these concerns. There's also the Family Advocacy Support Service, which plays a very important role in supporting families that are characterised by family violence, both those who experience family violence and those who use family violence, in terms of referring to relevant support services, having specialist domestic and family violence staff on site to assist parties, and having a duty lawyer on site to assist with, for example, the completion of a notice of risk when filing that with the court. Very importantly also, there is an information sharing strategic framework that is directed at closing those gaps between the fragmented nature of our Commonwealth and state and territory system, where we have the family violence orders progressing through the state and territory court systems, and the family law matters being dealt with at a Commonwealth level. So information sharing measures across relevant agencies is critical, and the information sharing strategic framework is an important factor there, as is the recent amendments to the Family Law Act to support information sharing as well, broadening the court's capacity to make orders to require the production of documents. So this ensures that all possible steps are made to have the relevant information before the courts when they're making these critical decisions, and also supporting families to be triaged through the system and referred to external services. That is a critical observation that has been made through successive pieces of research in the family law space at the Australian Institute of Family Studies, but in other by other means as well, that we need to better provide holistic support to families, wraparound services to ensure that they're getting the services they need. Critically also, the court has established a range of specialist lists to support and direct attention and better case management for particular cases such as these that require that have complex issues and require significant support in progressing through the system successfully.
Thank you very much.
Thanks, Doctor.
Thanks, Deputy Chair. Mr Newman.
I'm interested in the continuing professional development for lawyers who practice in this area. I'm aware as a Queenslander, as a former family lawyer, that a specialist who practice in the area, I'm aware that you have to do, say, 10 points or 10 units, 10 hours to get your certificate, to get every year and keep evidence of it. But there was additional requirements you had to do if you're an accredited specialist, particularly if you practice in the area regularly, and to promote yourself as such. But there was nothing specialised that you had to do in areas of domestic and family violence. So you could do something about the recent case law development, recent High Court decision, a lecture that a judge or a King's Counsel might have done, or at a family law conference. But nothing in particular that was geared solely towards domestic and family violence. I'm interested in your thoughts on that. That's one. And secondly, what judges and magistrates have to go through who actually adjudicate in these cases. And thirdly, police officers as well.
Thank you, Mr Newman. Very important observations that you make. And again, successive pieces of research and evaluation from the Australian Institute of Family Studies has highlighted the importance and need to upskill the family law sector, and indeed all professions that are engaging with families who are characterised by family violence and are going through the post-separation process. Training and professional development that is not only trauma-informed to understand how to best support families characterised by these concerns, but also domestic and family violence informed, so that professionals can understand the nature of domestic and family violence, how it presents, the dynamics between the parties, to avoid assumptions about the behaviour that a person who's affected by family violence would present as, to avoid disbelief when allegations are raised, to avoid misidentifying who the predominant aggressor is in a certain situation, and to ensure that we are identifying systems abuse where that is taking place. So it's critical to provide professionals with those skills so that they can ensure that when engaging with families, these dynamics are observable and responded to appropriately. These consistent themes emerged again in relation to our most recent piece of work examining the compliance and enforcement of family law parenting orders, where families responding to our survey of parents and carers did speak about the concern, despite significant improvements that have occurred since our evaluation of the 2012 family violence amendments back in 2014, significant improvements since then in the way in which services do approach this issue of identifying, assessing and then responding to family violence. Nevertheless, that most recent compliance with and enforcement of family law parenting orders research did identify that there remained concerns about professionals across the family law system who may not have identified those particular dynamics of systems abuse, for example, in the context of that contravention process, or who were not equipped to appropriately identify and then respond to those dynamics in the context of those proceedings. So, although there's been significant steps to support professionals to upskill and to emphasise the importance of having these skills when engaging in the family law space because of the high rates of family violence in that particular cohort, there is still some way to go, it would suggest, from our research.
Can I just note, Dr. Carson, our time is rapidly disappearing, so if you could keep answers relatively tight, because I know other committee members are keen to ask questions. Mr. Newman, is there anything else you'd like to
I just want to know
ask?
one of the... I'm just going to put a proposition to you and then I'll let you answer it and then I'll go on. That'll be the last question, Chair. It seems to me that one of the recommendations this committee, based on the submissions we've had so far, could be that as part of continuing professional development, certainly in accredited specialists, but generally in lawyers who practice in this area, that an obligatory aspect of professional development could be compulsory or mandatory training in the understanding of the implications of domestic and family violence and the evolution of that. And I'll put it to in the context, go back 20 or 30 years ago, we thought that domestic and family violence was physical or sexual assault and the likelihood of occurring again. Now we understand coercive control, financial domination, familial isolation. We understand that much better. So I'll put it to you that what do you think of the idea of making that mandatory as part of accredited specialisation and also as part of continuing professional development if as a lawyer you practice in this area?
Our research would suggest that it is critical to ensure that those professionals engaging with separated families, especially those characterised by family violence, need to have that specialist training to support them to most appropriately and safely respond to these families.
Thank you. Thank you, Chair.
Thanks, Dr. Carson. And I want to acknowledge that we've been joined by Ms. Doyle, and I'm not sure that her she's on a new device, so we'll she's observing at this point. But Ms. Chaney.
Thank you very much, Chair. I'm interested in your comments on causal connections, with the data showing that the more involved they are in the legal system, the chance of violence increases, whether that's because they're the cases in which you need to go to court, or if the experience of going to court contributes to that increasing rate of violence. Do you have any research or intuition on that?
Well, our research establishes an association rather than a causal link, but the qualitative data does help us to understand that, particularly from parents and carers who were engaged with the court system over a prolonged period of time in those particularly difficult cases involving issues with compliance, that in engaging in the court processes, that was a traumatic experience for a substantial proportion of people who were doing so, and indeed was a reason why families elected not to return to court on occasion.
But and the link to violence, what I'm interested in is that also then contributing to more violence? If you're in a protracted court case, does it actually contribute to there being more violence, or is it more likely to be the other way around?
Our research hasn't specifically investigated that question. However, our research would indicate, given particularly those families who are engaged repeatedly or over protracted periods with the court system, that they are more likely than our representative sample to be characterised by family violence. So there certainly is an association there.
Yeah, okay, thanks. Another question just about many victim survivors are misidentified as perpetrators. And I'm interested then also, and you noted some recent insights, that a high proportion of respondents in the family court contravention applications are more likely to be nominated as the protected party in state FVOs. Just wanted to talk more about that. So does the evidence show that women are increasingly prepared to breach family court parenting orders because of their concerns related to FDV, or what's going on there?
Yes, so there is a range of factors that could be occurring there. Certainly, that is one of them. That acting protectively may mean that families are having to make decisions about compliance. Certainly in that context, the data from our compliance with enforcement of family law parenting orders projects shows that. Underpinning those contravention applications, in large part, is those very complex dynamics of high rates of domestic and family violence, concerns about controlling behaviour, continuing that control subsequent to separation through the engagement in processes, including potentially using the family violence order process as a means of doing so on the part of those who are engaging in that contravention system and potentially using the contravention system as a means of continuing to perpetrate that form of abuse. Yes, it is certainly a characteristic that emerged, particularly from the qualitative data.
So using both the family court system and the FVO system to perpetrate, or more one of the other?
That is a potential, and indeed our earlier research on domestic and family violence and parenting, that was a piece of research that was funded through ANROS, identified a range of systems and processes that could be weaponised against the party who is the predominant victim of domestic and family violence. So yes, that is a feature of these families as well.
Thank you. And one last question. Just interested in what you've learnt about the complexity of there being multiple court systems, simultaneously, if people are involved in both violence and family court and
Yes.
people's experience of that and its impact.
That's right. Well, that fragmented nature of the system is particularly challenging for families who are already going through a very difficult time, very stressful time when separating, and particularly where that is characterised by family violence. Safety is the number one priority, of course, for a family, and then having to navigate multiple systems to receive the support that's required is particularly difficult for families. So to the extent that it is possible to co-locate these services, to the extent that it is possible to provide more holistic support and case-managed approaches so that families can have a no wrong door approach to receiving support is critically important.
Thanks, Chair. I'll leave it there.
Thank you. Now, I'm just going to check, Ms Miller-Frost, there is time if you do have a question.
No, part of the joy of being at the end of the queue is Mr Cheney's asked my questions, so thank you both for your evidence anyway.
Yeah, I think we've covered a lot of ground there. I'll just double check. Ms Doyle, is there anything you'd like to ask before we move on?
All good.
Thank you. Well, look, thank you very much for your attendance here today. You'll be sent a copy of the transcript of your evidence and will have an opportunity to request corrections to transcription errors. Please send your responses to any questions taken on notice during this hearing to the Secretariat, and thank you very much. And I now welcome the National Women's Safety Alliance to give evidence. I'll just take a moment to... Now, I'm just wondering, for future witnesses, we will be possibly looking at the screen when one of our fellow MPs is asking questions. If you feel uncomfortable because you're immediate below it, feel free to move one end or the other. But you're right in our eye line, I noticed. It must have felt very odd.
Thank you.
Okay. Now, for the Hansard record, would you please state your full names and the capacity in which you appear before the committee?
My name is Catherine Burney and I'm the Executive Director of the National Women's Safety Alliance.
My name is Isla Siskovic and I'm the Executive Manager of Legal Services and Principal Lawyer of InTouch Multicultural Centre Against Family Violence.
Good morning, I'm Therese Edwards, the CEO of Single Mother Families Australia, phoning in from Ghana Lands.
Now, actually, we have you in the next session. Oh, you've moved it in. I apologise. Mine is out of date. It's lovely to have you, Ms Edwards.
Thank you. Nice to be here.
So I need to say, I haven't noted that we're also including in this discussion representatives from Single Mother Families Australia. Yep. So as part of the alliance, yes. I'm assuming. There you are. Yes. It's always good to get that straight, isn't it? No problem. Now, although you're not required to give evidence under oath, this hearing is a legal proceeding of the Parliament and it has the same standing as proceedings of the House. The giving of false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Do you wish to make a brief opening statement before we proceed to discussion?
Certainly, and thank you, Madam Chair. I'll be giving a brief opening statement and then the context of my membership as well. So I want to begin today by acknowledging the traditional owners and custodians on the land of which we gather, the Ngunnawal and the Ngambri people, and pay my respects to their elders past, present and future, as well as acknowledging any Aboriginal and Torres Strait Islanders who may be in the room or online with us today. The National Women's Safety Alliance brings together over 700 individual and organisational members to provide policy guidance, lived experience and frontline expertise to inform national policy and reform on women's safety. We are appearing today with our members InTouch and Single Mothers Family Australia, who have played a significant role in how we have approached the inquiry. The inquiry into family violence orders is critical as it presents an opportunity to address the systemic issues affecting the safety and well-being of victim survivors, many of whom are also children and young people nationwide. Family violence orders play an essential role in protecting survivors from further harm, yet we know that the current system does contain significant gaps. Too often, we have found from our members FVOs are undermined by conflicting parenting orders or ineffective enforcement across jurisdictions. Our submissions highlights the serious inconsistencies between state and federal court rulings that can place children and their protective parents at greater risk. The adversarial nature of most family law proceedings further compounds the issue, allowing perpetrators to, at times, manipulate the system, often placing control over victims under the guise of parental rights. We urge this committee to prioritise reforms that strengthen the visibility and enforcement of FVOs, including real-time information sharing between courts and law enforcement. Additionally, we have advocated for a co-location model where family violence order applications can be streamlined within the family courts. This model would reduce administrative burdens and ensure the safety of children and survivors is consistently prioritised. Family violence orders must be more than just legal mechanisms. They must offer real protection. There must be a commitment from all sides of government, law enforcement and the courts to build a system that truly protects the Australians who need it most. I welcome the questions from the committee and would like to hand to Therese Edwards.
Ms Edwards.
Hello, thank you. So first of all, I do thank the committee for their resolve and the government for looking at this issue. I also acknowledge our traditional owners, and my heart is always with First Nations single mothers. And thank you for the leadership of the National Women's Safety Alliance. Probably of no surprise, our work is deeply rooted in the real and often harrowing experience of women who face safety risks and are also the primary caregiver. Parenting plans are under the federal government's jurisdictions, while family violence orders fall within the purview of the individual states and territories. This division of responsibility gives rise to safety concerns as family violence orders can be overruled by parenting plans, leading to unsafe situations. This creates a dynamic where perpetrators can exert control and gain access to their victims' living arrangements, their work, their personal information, and most critically, their children. Culturally, the system is more attuned to enabling contact than protection. And this is not surprising due to the long-standing and unsafe legislation that has recently been redrafted. However, the treatment of AVOs is another pillar of safety, and today I really hope that we have some dialogue and some outcomes that bolsters that safety. Thank you.
Thank you. Mr. Skovich.
Yeah, thank you. Thank you for the opportunity to appear today. Before I begin, I would also like to acknowledge the Ngunnawal people as the traditional owners of the lands which we're meeting today, and I pay my respects to their elders past and present. So In Touch is a specialist family violence service for migrant and refugee women. We're a multidisciplinary team with specialist legal services, and we provide services throughout the entire state of Victoria, from prevention, early intervention to case management and legal services. We provide our services in language and in culture in around 30 different languages. I've worked at In Touch for nearly 3 years, and prior to joining In Touch, I was at Victoria Legal Aid as a senior lawyer in their civil justice program. Importantly, I have some understanding of what our clients go through, as I came to Australia as a refugee during the Bosnian War. We've filed a detailed submission with many case studies, around 10 case studies that talk to what our clients experience. But if there are two things I would like to highlight, it is the unique challenges and barriers that migrant and refugee women face. And our submission goes through the complex needs that they have. About 44% of our clients were on temporary visas. About 32% had been in the country for less than 5 years, so it's 1/3. And at the point of engaging with our service, about 25.6% of our clients, so a quarter of our clients, had nil income when they engaged with us. So we support some of the most vulnerable women and children in our society, and we really strive to do our best to ensure that they have access to justice. about 91% of the clients that we dealt with spoke a language other than English. And so that's highlighting that critical importance of providing culturally tailored support. The second issue that I'd like to really highlight is just the complex legal issues that our clients face. It's with the intersection of migration, family law and family violence. And that's, I think, a critical aspect of how complex their circumstances are. So these 2 points emphasise our recommendations for improved understanding of risk during court proceedings and a broader understanding of family violence and how it applies to this group.
Thank you very much. I might, given you had very little opportunity in the last one, I might turn to you, Ms. Miller-Frost, to start us off.
Thank you, Chair. I'm really interested in that notion of co-location. Because co-location is not really enough in any service model. So how do you actually see that model working, and this is to all of you, and how would we overcome the sort of jurisdictional legal barriers that particularly, Therese, you mentioned in your submission? Hand it over to whoever would like to respond.
So we've covered co-location in our submission. I think the issue is that clients come to us with a problem that is involving their whole family. They can't dissect, and it's really hard, particularly for our client group, to understand the system. They don't know the difference between state and federal, and the risk is there around family violence and safety of the children. The issue is that often it's both proceedings at the same time, and often the family violence intervention order is given and then it's for 12 months, but the family law proceedings go for years. And so what happens is our clients are then confused, well, why are we then having to litigate? And it's at that extension of the intervention order that it becomes what I call a real battle. And clients have to retell their story, and we have to do further and better particulars, and family law proceedings are on foot. So I had just 2 weeks ago, I had a case where on the Friday we had a directions hearing for family violence, on Tuesday we had family dispute resolution, and on Thursday we had a compliance and readiness hearing. And so it's not just an interpretation issue, it's how do you ensure that as a lawyer my client fully understands and is able to give me instructions about the issues that are facing them. And what we see is when I appear in the family violence jurisdiction, all I can do is talk about the risk, but in the family law, in the intervention order jurisdiction, but in the family law, there have been risk assessments that have been done. The child impact reports are there. There's a family report, and it all talks about the risk to these children, but the magistrate doesn't have that information before them. And so why are we relitigating? If one court has made a decision that the risk is high, why isn't that before the magistrate? So we certainly in our submission endorse better information sharing between the two courts, and we see two circumstances where this could work. One is what we regularly see is when the family law proceedings are on foot and the intervention order expires. We think that would be a really good way for the intervention order to be co-location. And the other one is when the family law proceedings have been initiated, and then there's a need. We also have the situation. There's a need for an intervention order. The other group of clients we have is that women that we see are scared to go to the police. They're scared to approach, and they don't know that they can go and ask protection. So when then there's a family law proceedings, and then we say, oh, hang on, you're really at risk, you need an intervention order. So then we will go and apply for an intervention order. So those are the two scenarios that I think would, in practice, work best.
Anyone else?
Now, Ms. Chaney. Oh, unless have you got more questions?
No, I'm good.
But does anyone else want to add to that issue?
I think that we have had significant reform within the Family Law Act, which is excellent. But we haven't actually had it in play long enough since April, when the laws were gazetted, to actually evaluate its efficacy in terms of how we think about safety of the child and how we prioritise safety of the child. I think what we've just had highlighted here is often that isn't taken into consideration because we do have a a model or a method that has been considered what is in the best interest of the child. Now, these laws have come through to centre child safety at it. Part of the national plan is how we actually start to progress looking at children as victim survivors of violence in their own right. And we also now have the ability to look at systems abuse in terms of if there is a perpetrator abusing a protective or primary parent, is the impact of that abuse still in the best interest of the child then to continue that relationship in a house where either coercive control, financial abuse, or any other forms of abuse is still taking place?
Thank you. Ms Chaney, I'll go to you.
Thank you, Chair. I'd love to learn more about information sharing between the different courts, how it works and how effective that is.
Thank you for your question. I think it is lacklustre at best. I think we're lacking what a best practice looks like. I think that through the federal court, we have some interpretations of what is best practice in terms of information sharing, but whether or not that's consistently applied across the nation, I am unclear. I think that information sharing, as we look at the holistic issue of domestic and family violence, is a considerable problem. We have people falling through the gaps along each point of their interactions with services. So we take the case of Kelly Wilkinson, which is horrific. I'm sure the members are familiar with this case. She was engaged with not only a domestic and family violence service, she was engaged with a sexual violence service, specialist service. She went to 5 police stations. She had family violence orders and she was murdered. This case is so horrific it begs belief, but we hear consistently that this is still happening. So, for example, we had a member reach out to me on a weekend. National Women's Safety Alliance can't provide therapeutic or legal advice, but this was a Sunday and this person was desperate. They had their AVO breached on the Saturday. They are awaiting parenting orders. They went to the police on the Saturday, gave their video evidence. The child said, I don't want to ever see my father again in this case. The police said, well, we can't do that. You'll need to go to another legal service to have him added to the family violence order, as there was inherent risk to their safety. At 10 o'clock that night on Saturday, they said, well, because the individual didn't speak to you directly, there's no breach of the family violence order. They approached the children. I'd like to add at this point in time, the children were 4-year-old twins. So why would they be without their mother? I feel like this fundamental lack of understanding between law enforcement and the people who are administering the law that is meant to protect people and not sharing these risks are what is causing an even greater problem when we start to move out to multidisciplinary services like AJ's, because they've also now got to do safety planning and protection planning alongside of the legal advice. And it's critical that we start to have a more multidisciplinary approach through all our responses, because the information sharing nationally is poor.
Thank you.
Thank you. I've had a constituent who has had a family violence order, got a family violence order against her ex-husband, and then 2 days later has to go to court and appear 4 metres away from him. I'm sure that happens frequently. What do you think can be done to avoid, to make the two systems work better together so that the family violence orders can actually be imposed in the context of family court disputes?
If I would love to answer that, if I may. I really share the view of my colleagues, and I don't understand why it's still so complex. There has been a recommendation, a long-standing recommendation for some time, to have a live dashboard that would have all before before the court system, live and updated information on AVOs. Also, the gap means that child protection orders are often missing. And in those child protection orders, there can be the voice of the child or a professional who's made a safety determination upon that child. And it was about a month ago, I was in Services Australia looking at their new system, and they just had a wall of live contemporary information. They knew where there was log jams, they had social media, they knew where people were calling from, and it was quite a complex but very detailed system. And as I was standing there, all I could keep thinking of, if this was applied to women's safety, women's and children's safety, we would be in a much better situation. Like, we already have the technology. But I think Catherine has been really also talking about the culture. So when we have a federal system and a state system, the federal system has always taken primacy. And so all of a sudden, all of those safety concerns become secondary and subsumed. So sometimes that safety gets whitewashed out. And if I can just, so this is something that I think we can do today as a recommendation. But women are in impossible, unwinnable situations. In preparation for this inquiry, one woman spoke about her court system and her school system. Her school, which is quite replicated and mirrored across Australia, does not necessarily have to take into consideration ABO orders, but must take into consideration parenting plans. She had an ABO order and not a parenting plan. She was aware of the children's safety because he would use school to access the children and take them away. And she was often in fear of whether they were alive or not, or whether they would be returned and their safety and welfare. So she decided to go and get a parenting order to try and stop the school system being used as his location and place where he could access the children, and the parenting order gave access. And that's why she didn't have her parenting order. So in fact, even with substantiated and significant ABOs, which were multiple, that was whitewashed, and she went forward with that parenting order. So there's two parts in that. It's the not having the information, which I think goes to the nub of the collocation. But in the interim, and even to support that collocation, we don't need, in this age of technology, we do not have to have critical pieces of information falling through the system. And then culturally, we need to make sure that ABOs and past ABOs, police-initiated ABOs, concerns from child protection, they should be before the judge. And if they're not, we need a system to make sure that there is. And I would suggest that we already have that, but it is just not used in a way that could certainly help. So we know that there is capacity for the police to go to the magistrate and ask for an updated parenting plan. So I hope that answers your question.
Thank you. Chair, have I got time for one more, or should we move on?
Yes, you do, because that was one that I was very keen to get an answer to, and thank you, Ms Edwards. That was really comprehensive. So yes, Ms Cheney.
Just another question about, at the moment, the system uses self-disclosure through a notice of risk. Is that system working? Is there any evidence or data or anecdotal or quantitative about whether that's failing to bring relevant information to the court's attention?
So what we see in practice, if I can also just go back to answering your previous question about information sharing before a magistrate's court, the extent of it is us raising it before a magistrate and saying there are family law proceedings, and the magistrate will note that that's a higher risk and we'll take that into account. but that's generally the extent. It really relies on us raising the issue or a client.
Us being lawyers?
Lawyers, yeah. Us, sorry, yes. Yeah. As legal practitioners, or if you're self-represented, you would have to raise that with the duty lawyer. So there's very little communication between the two. And as I go back to my initial, what I stated earlier, I think there's a lot of evidence that's before the family court that would be really relevant. And that goes to the question of it's not easy to get an intervention order for our clients. I think there's also there's this assumption that anyone can go and get an intervention order, and there isn't. People appeal. We've had county court appeals in our service as well, and it can drag on for years. In terms of the notice of risk, we don't see it. I mean, albeit we do deal with the most complex cases, and a lot of our cases are in the Evatt list. So the court is aware of the risk, and we raise it through affidavit material, but in terms of that notice of risk, I think that's more for the court's own sort of purpose, flagging it and noting it. But it's really through the affidavit material and evidence that comes through family court reports and child impact reports.
Thank you, Ms. Chaney. I'll go to Mr. Newman.
Can I pick up something Ms. Chaney was talking about? And it's a bit tangential to it, but it's also relevant to it. There's some changes that came in since May 2024, and that is the new changes to Section 60(cc), which listed the factors the court can look at in making a decision of what is the best interest of a child. It does take into consideration the safety of the child and people who care for the child, including history of family violence and family violence orders. Now, relevant to your submission, you talk about the fact that there's a power that magistrates in territories and courts have, and state courts under Section 68R, to vary those court orders. Now, we do know that under Part 7 of the Family Law Act, that when a child protection order is made at the state level, the existing court order that's in place is suspended in the federal jurisdiction. I'm wondering, and this comes back, I don't know that we need a legal change, but I'm wondering to what extent magistrates and judges get together to talk about these issues together, and whether there's a need for continuing professional development of magistrates and judges so they can communicate with each other and understand how these laws interact. Is there any ongoing professional development of judges in this space?
I would say that yes, we would absolutely support that. We did attend a family violence symposium hosted by the Chief Justice of the Federal and Circuit Court this year. That was the first time that justices and frontline services had met and discussed, and that was a really great opportunity. But I think when that meeting closed, I did ask the question, what is the continuing structure that we'll have to keep meeting like this? Obviously, taking people off the floor is, on a regular basis would be incredibly difficult for that community of practice. But we can't move away from the National Community Attitude Survey that says, yes, 91% of Australians believe that domestic and family violence is a problem in our society. However, 43% believe it's not an issue for them in their communities. Now, community, that includes police, that includes members of the court. So we can't move away from this idea that we do have an ingrained opinion in our culture that women make up lies to destroy the lives of men. We know statistically from Anne Rose that isn't true. But it is a pervasive argument, and it's been a pervasive fabric within the family court since we had the presumption of shared care, which, noted in the Senate committee last year, has been misinterpreted since its implementation, which was why it was so important that it got repealed. So I think it is incredibly important that we have the most up-to-date training available to people who are making life-changing decisions for people. Coercive control I heard mentioned in the previous discussion. That is a relatively new sphere of discussion. We haven't tested whether the criminalisation works. We don't have consistent process of criminalisation across the country. And yet we know statistically that 98% of family violence includes coercive control. So it has to be taken into consideration, but our mechanisms haven't caught up yet to make sure that that's consistently applied.
If I can just add, what we see in practice is with Section 68R, I think that we rarely see it being used. I don't think I have had it in my own personal case that I've seen. But I think that section encompasses where you have a family law order, and then a family incident occurs, and then it would most likely, I imagine, in practice happen is if you go to the magistrate's court and say, I need a family violence intervention order, here is a family law order, can you suspend this because there are safety issues? That we don't see that in practice. What we usually see is there's an incident, the police have applied for an intervention order, then there are family law exceptions in that intervention order, and then a few months later there will be an application in the family law. So the courts kind of practically are trying to align themselves in the sense that there's an intervention order with the exceptions, and then the family law courts, the magistrate's court assumes that the family court is taking the best interest of the child and safety concerns. And in practice, it doesn't work so well.
Yeah. My final question, Chair, and that comes on this point, is that the reluctance of magistrates at the grassroots level to then vary that order means that the person who gets the domestic violence order in their favour and then breaches that family court order results in further litigation in the family court because the so-called perpetrator who's denied, say, contact arrangements feels that they're not getting the contact with the child and the other person's breaching the order. And so there's a potential for further litigation. What do you say about that?
I think that there are two different functions. The family court, I would say, has more evidence. They have the family child impact reports and the family law reports, which are detailed and really look at the picture as a whole family and how that family would function. And I think that's how the system currently works, and they make specific recommendations. Whereas the magistrate's court, they're hearing 50 matters on the day. They're really concerned about the risk and making sure that the women and children are safe at that time. They're not really looking at what is in the best interest of the whole family entirely. So
I agree, but in the most egregious cases, surely they can do it.
In the interim, sorry, missed that. In the most
egregious demonstrations of domestic violence, surely they can exercise 68R. It's not happening at the moment.
Yeah, surely they could, yeah.
Thank you, Chair.
Thank you. Thanks, Mr Newman. Deputy Chair.
Thank you, Chair. I wanted to continue on with 68R. And having practiced as a lawyer in New South Wales, so we'll talk about the Magistrates Court. The applications are almost, you have your fact sheet or incident report, and then options to tick and flick. Not to harass, molest, assault, otherwise, not to go within 100 metres, etc. I had a look at 68R of the Family Law Court because I hadn't practiced in family law. Do you think that magistrates are generally aware that they have that power to deal with family law orders or control of parental controls?
I think they are. I would say yes.
Okay. Why do you think they're reluctant to use that?
I'm not a magistrate. I think it.
But you're a lawyer. Have you asked magistrates in the past?
I think the concern is that is the matter for the family law to deal with. It might be a cultural thing. I think the concern is, well, that's a family law overall review of the whole family and how that would best function. And so that there is a bit of, and that's what our clients say, and it's in our submission, that there will be kind of kick between the two courts as to, no, that's a matter for the family law, no, that's a matter for the risk is family violence is a matter for the magistrates court. And I think that's a really good question.
I think anecdotally, I can say that's something that we hear consistently from our members. That is a matter for family law. Even when someone has called a police to an incident, well, you will need to go to the family law court. I think people are aware, but we also know that cross-jurisdictional issues are messy. We know that family and domestic violence is messy, and people, it's not a black and white system. So I think that there is a reluctance to engage across things that perhaps people don't have the full understanding of. Yeah. I mean, obviously, not being a magistrate, I can't speak for that, but I can speak for victim survivors who are passed between agencies, jurisdictions, legislations, because people just either don't know how to kind of deal with it in a multidisciplinary way, or they just don't want to know.
If I can give an example, we recently had a case where our client was mis-ID'd and she was removed from the family home because her partner made allegations against her and she was a risk to a child. The police came at 9 o'clock and literally took her out of her bed, removed her from the family home and put her in a refuge. It took her, she didn't speak very good English, it took her 2 or 3 months to get through the system and be allocated, until she was linked in with us and we could make a recovery application. When we went before a magistrate, the police agreed she was mis-ID'd, and we put that to the magistrate, and he didn't want to deal with it and allow contact with the children because the proceedings were on foot in the family law courts and there was a hearing coming up soon. So it's that practical reality. There are proceedings on foot in family law, and it's hard, I imagine, to interfere in that process. There are 2 jurisdictions. Yeah. But that's what we're seeing.
That cross-jurisdictional issue, isn't that exactly why the co-location is imperative?
We would support a co-location model in instances like those, yes.
Yeah. I do want to add, if I may, and thank you for that question. There is a cultural timidness around bringing to the fore AVOs, and if I can give an example that is really of concern in our world, and that is women who are forced to stay close to their abuser and their abuser's systems. So under the parenting orders, the non-custodial parent can actually go to the court and deny any sort of relocation, irrespective of how many AVOs or unsafe the women and children are. So currently I'm working with a woman from the Sunshine Coast. She has 10, over the years there's been 10 AVO orders. He doesn't see the children and nor does he pay child support. And she lives in a place where she is always one small breath away from being homeless with 4 children because of the high rent and the lack of family. She's not allowed to leave to go and have that family support. So that's not unusual. I've not picked up the scariest, most difficult situation that is replicated. So there is a real timidness, and we know that legislation went through and it last year and it came enacted in May, but it still leaks when it comes to the importance of AVO. So I would simply suggest that if there are repeated and serious AVOs, that mitigates the control of the perpetrator who is giving that violence. But it goes to the heart of the timidness. And I think that's something that we're asking from the committee today, is a way of elevating and taking seriously those AVOs, because we actually see them get mediated away. We see them get whitewashed away. We see the police that have who've done the work to get that AVO just go, oh, okay. So now he's got access to you at a McDonald's car park at 9 o'clock at night or 8 o'clock in the morning. You must be terrified. So if I can just talk about that would be a great outcome that the committee could certainly look at.
Thank you.
Thanks, Chair.
Thanks, Deputy Chair. Yes, I think we've taken a journey around, and I've got a few more questions just about that co-location, because it's pretty clear from your evidence that there is a real barrier when, like, obtaining a family violence order, when there are parenting orders, in all those different issues you've raised. But as well as having co-location to streamline those processes and give the family violence orders the weight that they deserve when they're being considered against parenting orders, existing parenting orders in particular, what other benefits would co-location potentially provide for, do you think, in terms of shared support services or sort of that other range? If you've got thoughts on that, or each of you, I'd be very interested.
I definitely think shared support services, it would be necessary, but one of the things for us with the co-location model is we have legislation, as we've outlined in our submission. We would hope that a co-location and that structural change in a pilot would facilitate a needed cultural change. That's what's becoming urgent. We have laws that protect people, and yet because of this cultural timidness, which Ms Edwards referred to, we're not seeing them enacted to protect the people they've been designed for. So for us, yes, we are always in favour of a wraparound support service within a court for people who are going through domestic and family violence. But I think it is, how can a structural change help facilitate a much needed cultural change?
And with the clients that we support, they are isolated, they don't have family supports, things like childcare because of temporary visas. Just simple practical things. Going to court is not a simple thing for anyone, let alone for our clients. There's a lot of organisations that we need to do, linking them with court staff, making sure that there is safety in family courts when they enter, ensuring there is safety rooms are available for them. So I think court location would practically be a lot easier for them, and they couldn't do it without having the services that we provide. So we have case managers and we have a migration agent and a lawyer supporting that person. So co-location would perhaps make that more streamlined and practically easier.
And Ms Edwards?
Thank you. Triggering different courts and different processes have different triggering options. So, for example, the immediate referral to family safety services, that's not available through all the different touchstones of women and children's safety. So that's one thing that could be rectified if there was co-location. However, if there's no co-location, you could still ensure that triggering and that automatic referral to the family and safety services should be part of all the court systems.
But I do need to quickly add to that if we were to do that, we need to then look at what comprehensive funding for those services looks like to ensure that people who have been referred in are not facing long wait times, which we know is unavoidable in our current system.
Absolutely, and we'd also like to ensure that there is opt-out systems, because there are some women who would be terrified of taking that next step, or would need to take a breath, and there would also be that resource issue. But that's just is one point where you can see the real feelings of unsafe, the high risk, and it's treated differently depending upon which door you actually go through.
Can I just add also for our clients, there are VAS duty lawyers in each court and they do a wonderful job, and we do work very closely, collaboratively with them because we are a statewide service and we wouldn't be able to support women in regionals. But I could tell you what our clients need is they don't need a duty lawyer on the day. They need someone to help them with the paperwork, to sit down and do the affidavit with them, to sit down and go through their case and really prepare their case so that the issues are effectively before the court. And that is what our clients struggle with, obtaining effective legal representation at the time that they need it. And without our lawyers helping them, they would not have been able to navigate the system in any way.
Thank you all, and thank you for the work that you're doing to really protect and support women and children in really vulnerable situations. I think we all can see your commitment to it.
Thank you.
And we're really grateful for your evidence today. Thank you for your attendance. You'll be sent a copy of the transcript of your evidence, and we'll have an opportunity to request corrections to transcription errors. Please send your responses to any questions taken on notice during this hearing to the Secretariat. We'll now take a short break and we'll return in 10 minutes. Thank you all very much.
Thank you for your time. Thank you.
Thank you. Now welcome Domestic Violence Advocacy Australia, Full Stop Australia and Council of Single Mothers and Their Children to give evidence together as a panel. For the Hansard record, would you please state your full names and the capacity in which you appear before the committee? And why don't we start with Ms Glasson in the room and the organisation you're with?
Thank you. My name is Lara Glasson and I am the Secretary of Domestic Violence Advocacy Australia.
And now the others from that organisation.
Good morning, Chair. Emma Hassar, Chair, Co-Chair, Domestic Violence Australia.
Thank you. And do you have a third representative with you today?
She's currently in New York, and the plan was that she was going to appear, but it is midnight in New York, so if she is not here, we pass on her apologies.
Thank you. Well, we'll keep an eye open for Ms Martin. Full Stop Australia.
Hi, my name is Emily Dale. I'm the Head of Advocacy at Full Stop Australia, and our CEO, Karen Bevan, is also joining in a moment.
Yes, Ms Bevan, would you like to give your name and title, the capacity in which you appear today? We've got you on mute, I can see, or you might need to unmute yourself.
It's going so well. Thank you so much. My name is Karen Bevan. I'm the CEO of Full Stop Australia.
And Ms Davidson. Do we have Ms Davidson? No, not yet. Well,
Chair, excuse me, my name is Andy Sebastian. I appear in Ms Davidson's stead, and I arranged it with the committee at late notice yesterday. Apologies for that.
Thank you very much for that. It is very good to have you here, Ms Sebastian. Okay, so I think what we'll do is just introduce ourselves briefly, and then I'm going to ask you to make opening statements if you'd wish, but just to establish which committee members are here. I'm Susan Templeman, the chair of the committee, the member for Macquarie and Special Envoy for the Arts, so New South Wales-based MP. Deputy Chair.
Thanks, Chair. My name's Pat Conahan, member for Cowper, Shadow Assistant Minister for Prevention of Family Violence and Social Services.
Online we have Ms Doyle.
Yes, member for Aston in outer eastern suburbs of Melbourne.
Thank you.
And Kate Cheney, independent member for Curtin in Western Australia.
And finally...
Shane Newman, federal member for Blair, based in Ipswich in South East Queensland, Labor MP.
Now, although you are not required to give evidence under oath, this hearing is a legal proceeding of the Parliament. It has the same standing as proceedings of the House. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Do any of you wish to make a brief opening statement before we proceed to discussion?
Yes, Madam Chair, I would like to make an opening statement. Thank you very much. On behalf of Domestic Violence Advocacy Australia, representing the voices of victims of family violence, I wish to thank the committee for the opportunity to present. Our written submission provides 10 clear recommendations for consideration, and we are grateful to the other witnesses appearing in this session, and we echo their recommendations also. The key issues we want to speak about haven't been thoroughly weighed because not enough lived experience of victim survivors in family court is considered, with a view to implement the learnings. If the committee is interested to know what is really keeping women living unsafe in their homes, unable to leave, it's because the family court system keeps women bound, gagged and weighted down to their abuser. Are women really free to leave family violence in Australia if the court system is an inaccessible and unsafe place for victims of domestic violence to go to for support? Women are bound by orders made by the court. Victims of systematic abuse are gagged by laws which supposedly exist to protect women, namely Section 121 of the Family Law Act. And finally, the court weighs women down with long, drawn-out expensive adversarial battles which keep them weighted to their abuser, despite the safety risks this poses. By the time a matter has arrived in family court, it is clear to many agencies, including child protection, police, frontline services, and local courts, that there are significant safety issues, yet we drag victims through a cumbersome, expensive, drawn-out and adversarial process to divide assets and consider living arrangements for children because the piece of paper, called whatever it is in all the different states, intervention order, protection order, that they have to keep them safe doesn't actually mean anything in a family court. There is a stark contrast to how family abuse is recognised in parenting compared to property matters, where patterns of abusive behaviour are continued. Abusers can and do use the family court to continually perpetrate financial and systems abuse, and the system does nothing to deter or penalise this kind of abuse. Commonly, abusers will drag out proceedings with non-disclosures and delays, and victims of abuse are told that they might be able to apply for a costs order at the final hearing. The reality is that very few cases make it to a final hearing, so a costs order is rarely granted. If it is, enforcement becomes yet another problem for the victim to navigate. Orders cannot be enforced without again entering the court system and paying lawyers exorbitant fees. The entire process has a significant impact on victim survivors. We hear from so many victim survivors about how they had to tap out early from the court, accepting less than they may be entitled to, and with nowhere near enough funds for financial security. For those that persist, such as the case studies in our submission, many spend much of their settlement on legal fees. Some end up self-representing, or the majority do not even come to court because the system feels neither safe, consistent, or unfair. This is evident when you look at the fastest growing cohort of homelessness, which is women over 50 who have been victims of domestic violence prior. This tells us that the financial matters of victims of domestic violence are not adequately case managed in our family law system. The domino effects of abuse in the family law system are catastrophic, accumulative, and they put women on the back foot for the rest of their lives. Recovery from abuse takes years, and rarely, if ever, does a victim recover entirely. We raise concerns expressed by victim survivors that evidence which presents a pattern of abusive behaviour can be overlooked, and there is a heavy reliance on expert report writers in the family court system, while mountains of evidence of abuse, including AVOs, can be and are ignored, especially if that protection order has lapsed. A victim of abuse also faces the prospect of misidentification if they are not viewed as credible, due to what could be a trauma response. Data collection on misidentification is severely lacking in the family court system. Report writers who are not necessarily experts in family violence can misinterpret these behaviours. The over-reliance on these reports can and do have catastrophic consequences when children are placed in the care of the abuser. The only review process for these family law decisions is via a legal appeal. These are costly, involve long wait times, and they don't incorporate family violence specialists to review the finding of facts. Appeals must involve experts in domestic violence. Even with all the tinkering around the edges with the numerous reforms, the family court system is still unsafe. And we want a nationally consistent approach to risk assessments for perpetrator identification so that victim survivors can use the family law system safely. We cannot have a family law system where victims who have been through it say it would have been easier to stay and live unsafely until our children are old enough and then leave, like the women offered in our case studies. We hope that the committee will consider our submission to ensure that people living unsafely in their homes can leave safely in Australia.
Thank you very much, Ms Glasson, for your opening statement. Ms Sebastian, would you like to make an opening statement? Just unmute yourself. I know you'd think we would have worked it out during COVID, but we still do it regularly.
Absolutely. I spent half my life on video and still forget that basic thing. Thank you, Chair. I want to acknowledge I am on Wurundjeri lands, and I thank the committee for the opportunity to speak to our submission and to participate in this panel discussion. I will refer to some details in my opening statement, but these are completely de-identified. My focus is today on some key points for us. We raised in our submission the primacy of children as victims, and I want to speak in particular to that today, and particularly some early feedback that we're receiving about the way these issues are being treated post the amended legislation taking effect on the 6th of May. So first and foremost, our concern is that we contend that children must be recognised as primary victims of family violence. And in all but the most limiting of circumstances, the court must provide them with a voice. And we would add to that in some instances, this may need to be a confidential voice that does not provide parents with the details of what the children say. We're concerned that despite the Family Law Amendment Act prioritising safety for children in decision-making and supporting children to have a voice in decisions about them, orders are still being made in cases in which children have no voice. For example, Tom, who is turning 11 this week and is on the same family violence order as his mother, has previously spoken to a family court child expert. When the report of this expert, amongst other reports, was made available to the court and detailed some of the things that the child had said, and then the court recommended that the father have limited and supervised access with his son, essentially on the basis of the report of the child expert to whom the child spoke freely. The father punished the child with physical punishment. Tom has since been unable to speak openly with anyone, and the current ICL has made no attempt to speak with him. In our previous submission, I think we recommend strongly that the court, and in particular the ICLs, have to have training in really excellent communication with children. And if they don't have that, and that's fine, but they need at their own expense to employ somebody who does and translate that information directly from the child into the court. In this instance, earlier this week, on the recommendation of the ICL, whom, as I've just said, has never spoken to the child, the court has ordered he leave his mother's care and live with his father until a trial date next January. Now, that's de-identified, but it's true. And I raise it because one of the things, Council of Single Mothers and their children have been around as long as the family court. And so we have a generation of young people who have grown up under parenting orders that have pushed them back to the violence that they and their mother escaped. And we regard that as an absolute tragedy. And we're sure that there will be other people who will speak for the children. But our brief has always been single mothers and their children. And what mothers tell us is that, you know, in some ways, despite the poverty, and I absolutely acknowledge our former colleague who spoke so powerfully and so well, but women will say to us, in some ways, they would be prepared for those cost penalties if they felt their children were safe, if they felt the decision was a fair one that was going to allow their children to develop in their full potential. Where there has been no recent family intervention order, and the court then dismisses concerns about family violence on this ground, that it's an old order, nothing has happened since, so therefore the family doesn't be referred to the EVIT order, the EVIT list, the provisions of the court are supposed to be there for victims and survivors of family violence. None of this is brought into play. And what we see is real miscarriages of justice. Because in this situation, where the court has virtually dismissed any concern or allegation of violence, we see the stage set for misrepresentation of the real threat, with claims that the protective parent is the one being violent. I've sat in court and I've read orders and transcripts where it is abundantly clear that the allegations of the parent named as the perpetrator in the family violence intervention order are being given great weight. Phrases such as alienating the children from their father and coercively controlling the children are levelled at the mother, justifying the decisions such as the one that has sent Tom to live in the abusive household for which he and his mother escaped some 7 years ago. This demonstrates to us that while the parental alienation syndrome has been widely disputed and invalidated, the concept remains sticky. I asked the permission to provide the committee later with an article on this that is so close to the lived experience of some of the single mothers who contact us that it is unnerving. Finally, we find it astonishing, all the literature out of the Australian Institute of Family Studies about the composition of the cases that come to the family court. Make it really clear that family violence is one of the top issues. There's other things, there's mental health, there's drug and alcohol, et cetera, but family violence is right up there. And yet we see it's still underplayed by so many judicial officers at every level across the court. It seems to us that the foundation of the current crisis that sees 46 women killed this year, 11 more than this time last year, and 75% of whom are family violence related, is the long-standing and widespread community mistrust of women and children's reporting of violence. And I have a link that I'll provide to the committee providing the figures, which are astonishing, that, the Australian public has such a low sense of trust in the stories of the victims. Now, judicial officers, in our experience, are as much influenced by these misconceptions as many members of the public. In our submission, we call for a large investment of funds and expertise in training for all those involved in family court matters in the nature and impacts of domestic, family and sexual violence. We don't know if these sorts of funds have been available. We don't know if there has been any training of court personnel prior to the 6th of May and the beginning of this. We don't know if there are plans to do this, but we ask the committee, if you have the power, to find this out and make a finding in relation to it. We specifically also want this kind of training to include child development and evidence for particularly judges and registrars who are trying to make these orders. And we accept that they believe they are really trying to do the child's best interest. The goodwill is almost certainly there. But what we see very evidently is that they actually have very little experience of working closely with children, and that they often lack any real appreciation or understanding of the developmental stages of children, what children are likely to go through, so that a period of I can't give examples because that will just take me down a rabbit hole and too long. But we would like that training included so that judicial officers are well equipped to better appreciate the real challenges facing children for whom those orders are going to be made.
Thank you very much, Ms. Sebastian. A really comprehensive overview of some of your concerns. Now, Full Stop Australia, would our representatives, would one of you like to make an opening statement?
Thank you, Chair. Yes, we would. Firstly, I'm coming to you from the land of the Gadigal and Wongal people, which forms part of the mighty Eora Nation, and I pay my respects to elders past and present. Full Stop Australia, very briefly, is a nationally focused not-for-profit organisation which has been supporting and advocating on behalf of victims, survivors of sexual, domestic and family violence for 50 years this year. We provide 1800 Full Stop, an unfunded but excellent 24-hour, 7-day-a-week trauma specialist counselling service for victim survivors of gender-based violence to address immediate impacts of that violence and support victim survivors in their recovery. We work and have worked since we were established at a systemic level, focusing on education, law reform and policy and systems change in order to create a more supportive and better structures for all women and to create those sort of structures that will address gender-based violence. Our advocacy is guided by the lived expertise of over 700 survivor advocates in our National Survivor Advocate Program, and we're committed to centring the voices of victim survivors in our work. And I would like to pay tribute to my colleagues from Domestic Violence Advocacy Australia and the Council of Single Mothers and their children who bring that perspective so strongly to our conversation today. And I think that they have raised many of the critical points, so I'll direct my comments to areas that have not already been covered, although we have noted some very similar issues in our own submission. So we really welcome the inquiry because what we think it recognises is that, let's face it, family violence is core business for the family court. It always has been. And we absolutely need to make sure that we are constantly evolving this system to make victim survivors, both children and their mums usually, safe as they navigate the family court system. We believe that the family court system should not be another part of the use of systems to create violence and control. And we believe that this should be a safe place for women and their children. And we know that for so many women and their children, it is not. And what we do know, to keep our comments very focused, is that we have extreme risk being created through the family court system. And there is a lack of alignment between what we know about risk and how it operates in family violence, risk to women and risk to children, and how the court operates and how it intersects with other courts. So we know that these risks are very significant. The research gives us very clear ways to act. So sadly, the most insightful parts of what we know come from the review of women and children who have been murdered by their intimate partners. And what those domestic violence death review team work tells us is that we absolutely need to address risk in every system and avoid the use of systems to increase risk. So here are some of the things that we think are critical. We need to really consider whether the culture of the family court has an ability to keep women and children safe. What we've seen, and with the entrenchment that will be very difficult to undo of the equal time proposition, that we've seen a decision-making structure characterised by the lack of understanding of the nature and dynamics of domestic and family violence, disbelief of serious allegations of harm, and ignoring children's voices. And that is reflected when we look at the research from domestic violence death review teams. Those elements are present in many, many cases where women and children have been gone on to be murdered by their former partners. The use of the family violence, the use of the family court system as systems abuse is very significant, and we see perpetrators use formal processes to gain access to their victims and perpetrate further harm. We know that risk mitigation, based on the evidence of how risk works and the escalation of risk to women and children, is not well taken into account in the family law system. And as such, clear elements of risk through family violence orders are not addressed through the way the court operates, and that needs to change. We need that the intersection between family court proceedings and state and territory violence order schemes, we need that to be less complex, less cumbersome, and less time-consuming and difficult to navigate. Otherwise, we are about to submit ourselves to designing programs to address the fact that these systems are complex, cumbersome, expensive and time-consuming, instead of addressing the problem, which is that the system isn't working for the safety, well-being of women and children. So we recommend, firstly, we welcome recent reforms to the Family Law Act, and we think that that will assist. However, we are undoing 20 years of practice. We are undoing, as my colleague pointed out, a systemic approach that disbelieves and treats women and children as unreliable witnesses to their own life experiences. We are actually trying to undo a very significant cultural problem. But going forward, we think that we need to think of this in the broader context of the need for wraparound services so that victim survivors entering the court system have access to support as they navigate. And we need to make sure that particularly women's legal services, but generally sustainable funding for legal services is available to provide critical support. We also recommend that systemic failures allowing known risks to escalate must be addressed. So, for example, we support better alignment between the risks identified in family violence orders and parenting orders made in the family court. We recommend that there is a significant review of why Section 68R is so underused for the protection of women and children, and why it is that the ongoing practice in the family court of making parenting orders that are at odds with family violence orders, that ignore family violence orders, and that increase risk to children continues. We note that recent research by Monash University found that 1 in 5 domestic homicides, there was an active family violence order, and yet so often these are ignored by the family court. We need a comprehensive program of education, including, and this is probably the critical change that we see required, including the stories and the expertise of people with lived experience of family violence in the court for all actors in the family court. Training should cover the dynamics and drivers of family violence, well-known risk factors, how trauma operates, and the risk of systems abuse. And we support proposals that would streamline the interaction between the family violence order schemes in each state and the family court. And we consider some colleagues in the sector have proposed a collocation pilot. There are, reasons why that may provide some relief in the immediate term, but overall we believe we must address the underlying drivers of risk to women and children in the family court, which is that poor understanding of how all of these matters intersect and the treatment of women and children as unreliable witnesses. Thank you for inviting us to appear today. We appreciate the committee's important work.
And we appreciate the expertise and life experience that you bring to these hearings. Now, I know there are a number of questions from the committee, and some will be directed to one organisation and others will be broader. I'm very mindful that we will try and get through a lot in the next period. So if you could keep answers brief, and if someone, feel free to say, ditto, I agree with what the other person said. Look, I might just ask a general question to each of you. and some of this you've touched on, but essentially of the experiences of the clients you've advocated for, or the life experience, the lived experience that they have, or you yourselves have, of those that are going through the family law system, is it very common to experience escalating violence once proceedings are commenced? So feel free.
I'll start because perhaps we have, we're not a family violence service, so we often hear things in retrospect. The escalation we see is a bit like with those old family violence orders, which might have been around physical violence and relatively easy to prove, where it changes. And we see the change happen again in family court matters. It changes into a very brutal, nasty kind of psychological violence. So the threats to women and children, like the threats to women, I tell you, you will lose your child. I'm going to bankrupt you. You know, I'll get every cent out of you. The threats just keep coming. They're often not subtle, but they're hard to prove because it's he says, she says, and no bruises. Child support becomes another thing that is weaponised. Somebody who may have been paying child support suddenly says, right, well, that's it. And bringing in other friends, family, and vilification.
Thank you. Would anyone else like to add to that?
Yeah, I'm now unmuted.
Thanks, Ms.
I think in my experience, and I'm someone with lived experience of the family court, is that it becomes a bit of a gotcha and a game to the perpetrator. So anything that you say or do is written down and taken way out of context for them to try and get intel or evidence or whatever on you, so that you start living and parenting in an entirely different way because the psychological games and abuse ramps up. The issue with when you take it to court and you're presenting your evidence to a judge is that quite often they think because you've left the family home, you have thereby left the violence. And there is never a consideration about what happens after that. So the culture of the family court, which Karen spoke well to, is that the belief that if you've moved out, well, the violence has simply just ended. But while you're going through proceedings, the perpetrator, usually a man, will do everything in their power to ensure that you basically start living even more on eggshells, worse than you were in the home, and that you parent in that same fashion.
Thank you. Ms. Glasson.
Yeah, I can add to that. So some of the experience that I have come across is that the abuser will start attacking the victim with false allegations of abuse and things like that, like doctored photos of injuries that then get presented into an affidavit. There's also increased financial abuse where insults are sent via bank deposits for child support payments. And it becomes like a whole nother level of learning that you do as a victim survivor because you are so used to the abuse that happens in your home. It changes and evolves, and you need to learn and figure out how to handle a whole different type and level of abuse once you're in the family court system.
And just to clarify, when you say via child support payments, do you mean the message that goes onto your bank statement?
Yeah.
Thank you. I'm going to hand to my Deputy Chair.
Thank you, Chair. I do want to just continue on, and thank you everyone for your evidence today. I know there's a great deal of public interest and there are a lot of people watching and listening today. I do want to continue on Ms. Hussar, you mentioned the word weaponising, and you were referring to weaponising the actual system, the family court system, rather than the nastiness of affidavits and doctored photos. Would you talk about how individuals actually weaponise the system to effectively increase that family and domestic violence?
Yeah. So, look, there are, and when I say these, they all sound very small, but once they're all wrapped up and sewn together, you can start to see a pattern. So things like forcing contact through lawyers. So rather than being able to communicate very basic changes, they insist that the letter goes through their lawyers. So that's a weaponisation of the system where they're causing my lawyer to have to respond via their lawyer, which is thereby increasing the fees that are going to be posted to each of those people in there. The system is often very slow. So the weaponisation can also involve things like not providing full and frank disclosures. There is no teeth that the family court has in terms of making sure that those disclosures are made full and frank. So you can spend months and months and months going back and forward, and every time you appear before a judge, just think about the legal costs that are incurred in those. There's also the weaponisation of the system where the false allegations will be made that the victim quite often has to defend. So, you've then got to go out of your way to find more evidence, more experts to, put weight to your case, because those affidavits are sworn, they're considered by the court to be factual, no evidence is required. You might see people throw around things like mental health issues, or they want the full health documentation of the victim, which is, again, more cumbersome on the victims who are going through it. So that's a couple of ways in which the system is, in fact, weaponised. There is the disagreements over which family report writer they're going to use, whether they're going to go to private mediation, or, you're going to pay for or go through the public version of the mediation process, which can also stall proceedings. And then, of course, the weaponisation exists once those orders are put in place, where the perpetrator, more often than not, will ignore the orders that they've gone to court and fought so hard to get. They are black and white. They are very easily to interpret for someone who has a degree of literacy, and they will then cause their victim to have to go back to court for a breach of those orders that have been made, because, of course, you can't call your local police if the perpetrator is flaunting those orders. You just have to suck it up, put in another return to court application, go back through the process again to have those orders, which a judge has already put into place, recognised by the perpetrator. And there again is no penalty, there's no deterrent, there is absolutely no responsibility needed to be taken by that perpetrator.
And if we can just carry on with that theme, and Ms. Bevan, you mentioned, you said the culture of the family court. Could you just expand on what you meant by the culture and how that impacts on the weaponisation of the family court?
Thanks. Thank you so much. I think what we're talking about is that we have a culture that's been embedded in a sense of equal time as a presumption. It's been embedded in a sense that people make allegations to the family court that aren't true, that there is this kind of view that everyone who's there is trying to weaponise the family court, and so women get caught up in that and seen as making false allegations. I think that as Ms. Hussar has
could
really...
I just interrupt there? And I don't dispute what you're saying, but where can we find that research that... because personally, myself, if somebody goes, if a woman goes to the family court and says, this is what happened to me, I don't automatically think, well, you're lying. But you're saying that there is evidence out there and research out there that is actually the case. Is that right?
I think that the evidence is really clear that family violence allegations in the family court have not been taken into consideration in the way that we would like them to be. I think that research has been done over the years that shows that family violence allegations have not been well considered. Yes, there is an evidence base there. Mm-hmm. I think the other side of that is that the victim survivors of family violence have been talking about this issue. One of the reasons that we're here, I suspect, is that we've heard women over and over talking about this issue. I have certainly seen women discussing the fact that these allegations were not well taken into account. So, yes, I think there is an evidence base. It's a complex area. Yep. And what we know about the family court is that those who actually get to the family court bring some of the largest and most, the complexity of matters that are being taken to the family court, given the kind of way that the family court has evolved over time. I think what we know is that people who are using the court are genuinely bringing some of the most complex concerns in front of the court and have many intersecting factors that can get in the way. So I think what we know is that the family court is actually as a front line to complexity. But over many years, the research has been there that family violence matters have not been attended to effectively. And when you look at the Domestic Violence Death Review Team work, we know that AVOs, for example, are a factor in almost every death. So 1 in 5 domestic homicides, there is a family violence order in place. And yet what we're here today talking about is the fact that family violence orders generally have not well been attended to by the court. So I think that, we really have to understand that this is a very real issue. And I think that there is real evidence that there has been a lack of understanding of the way family violence plays out in the family court. And I do think, we have seen some significant changes recently in the amendments to the Family Law Act. They will take time to be kind of integrated into the work of the court, because we've had many, many years of other ways of working, and we know that those have had negative impacts on women and children.
I might also jump in.
Just on the
apologies. Do you mind if I just quickly jump in, Senators, and just add to that?
Of course, Ms Dale.
Thank you so much. In relation to that evidence base, there's some really useful studies that are cited in the submission of the Australian Institute of Family Studies, who I believe were also before this committee earlier this morning. Some of those studies, which I might draw your attention to, include studies that demonstrate a lack of understanding about the nature, dynamics, and different forms of family violence, as well as a culture of disbelief and dismissal of safety concerns, and inability to identify systems of use. There was a study by Heather Douglas in 2021 and Michael Salter and other colleagues in 2020. There's also a large evidence base demonstrating that the family court has a pro-contact culture which prioritises shared parental responsibility at the expense of safety and properly addressing risk to victim survivors of family violence, including both mostly mothers and vulnerable children. And the studies that are cited in the Australian Institute of Family Studies submission are Carson et al., that's from 2020, Caspew et al. From 2015 and 2022. I would note that Full Stop Australia was very supportive of the amendments to the Family Law Act that commenced in May, and the effect of them yet to be seen. And we hope that will go some way towards addressing the sort of entrenched prioritisation of shared parental responsibility at the expense of safety. I think that what these studies demonstrate is a real failure to take risk into account.
Thank you, and that was the answer I was looking for. Thanks,
Thank
Chair.
you. And I think, Ms Glasson, you wanted to add something too.
Yeah, if I could. So there are there are cases in the family law system that have described the abuse as situational. So they have described that it only exists in the family home, that it's only when the husband and the wife or the parents are together. And this has then led to contact being provided to the abuser of the children. And then this in turn has led to those children being used as vehicles of abuse for the abuser. There are statistics, which I'm happy to get to the committee after today, about the use of adolescent violence and how many children, adolescents, use violence in the home who have been witness to and victims of family violence, who then at the end of contact with that abusive parent come home and physically assault their other parent. So I'm happy to get that research to you if that's something that you would like after.
Yeah, thank you.
Yeah.
Thank you very much. Now I'm going to go to Mr. Newman.
Well, thanks very much. I'm very glad that you are supportive of the changes that took place in May this year, which abolished the presumption of equal shared parental responsibility, which led to people believing that somehow there was equal time and resulted in more litigation. So I'm very pleased you've done that. In fact, that changes are major, are they not? That even taking into consideration history of domestic violence against people in the family who don't have parental responsibility, such as a sibling or a grandparent, etc., that's covered as well there, isn't
it? Is that directed to...
does someone like to comment on that?
Full stop.
The previous speaker, I think, was Ms Dale, who was talking about it.
Yeah. Yes, I'm so sorry. Would you mind just clarifying the question one more time?
The changes in May this year to Section 60CC takes into consideration the fact that you look at the history of domestic and family violence and history, even towards family members and people who do not have parental responsibility for that child. It's a very broadening of the understanding of the history and the implications of domestic and family violence in those changes in May this year. Isn't that the case?
Absolutely. So we're very supportive of those changes and the fact that they prioritise the best interest of the child as the primary consideration when making parenting orders in the family court. And that's absolutely right, that a history of domestic and family violence is one of the factors that can be taken into account in determining the best interest of the child. We're really supportive, and I think that you've correctly identified, Senator, that family violence can be really complex in the way that it operates and the people that are impacted by it. So we hope to see positive change following that reform.
I approach those changes with, optimism, but also scepticism. We have seen, and this goes back to the culture of the court, for the last 10 years at least, the best practice guidelines have existed for judges. The best practice guidelines in relation to family violence have existed for a very, very long time in the court. They are optional extras for judges to consider. They've had the research, they have had those guidelines, they have had all of that guidance provided to them through those best practice guidelines. And on our research and on our experiences, those guidelines are very seldom put into place. The culture of, equal time with parents was something that was interpreted by the 2006 changes by the Howard government, and that was interpreted by judges. We talked about this earlier, and the lack of training for judicial officers, for ICLs, for family report writers. And what I want to say to this committee to take back really strongly is that we have experts who study social work at university level for 3, sometimes 4 years. We have experts that work in this field with years and years of experience. Family violence isn't something that you can put a judicial officer through a 2-week training program and then say, oh, cool, they're trained. It simply just doesn't help. It provides some, but it doesn't go a lot of the way to helping them to understand and identify, more importantly, the very significant risks to families and the significant risks to the children, because a 2-week crash course in DV and DV training is never going to go even close to what they need to know about domestic violence. And I'm not a social worker. I didn't study the degree, but I have great time and respect for those people who have. So I don't think that we can train our way out of this. I also don't think that the tinkering to the system again, and I point you all to the book Broken, Children, Parents and Family Court, which speaks to the enormous number of the changes that have occurred to that Act since it was rolled out in 1974 or 5. It is a constant, and, you know, my experience sitting on the opposite side where you are, Chair, we looked into this extensively during my time in Parliament. There was another ALRC review. There's been 2 more since that time. The family law system does not protect the victims, and it continues to weaponise the system against the victims, because there is absolutely no deterrent for a person who's used violence. So you can have an AVO given to you by a local court, and all of the violence that has been acted upon you recognised by police, social workers, the system, the $5,000, you know, staying safe violence grant, by victims of crime in New South Wales, and they've paid you out because they recognise you as a victim of crime. That perpetrator is allowed. They have every right. They are entitled, and I use that language because that's how they see it. They are entitled to go to court and ask for money of assets. They are entitled to go and ask for their children. When multiple other systems have identified risk and abuse, they are allowed to go into that court and be seen as an equal party in those processes. Now, what are we saying to perpetrators when they have perpetrated against their co-parent and their children, when we give them the right to access this? And so maybe we need to wind it back a bit and start placing some deterrents in this system where people don't have the right to just simply come in when there is a load of evidence that has already been presented to multiple other institutions and courts and systems where their violence has been recognised. I think that, you know, the tinkering around the system and the changes, you know, I welcome them, but I approach that with great scepticism, because I have people that we advocate for going through that system now, where the family report writer has recently written, oh, it's good that the father has locks on the doors because, you know, he's preventing the children from seeing the marijuana plants he's growing. So the perpetrator who's spent a lifetime committing violence is now being given gold stars from the report writer for simply locking the doors where his marijuana plants are going. And that is anecdotal evidence that was given to me this week. So I welcome the changes, but again, I don't think it's something that this committee nor the Attorney General should be hanging their hat on and saying, okay, job done.
Can I ask now a question? It comes up through Ms Sebastian's submission about the Council of Single Mothers and Children. You talk about unequal resources or situations between parties, meaning unequal access to quality legal representation. We've had evidence in this inquiry already that it's not just good enough for there to be some preliminary advice in family law proceedings for victims of domestic and family violence, that what we need is really, you know, proper legal representation, affidavits, which are evidence in court, legal representation in court too, because we're seeing an increase in self-representation in the court system. So without domestic and family violence, there's often an unequal power situation between people anyway, based on finance, physical situation. Add the domestic violence in, it becomes even more unequal. Well, I'm going to put it to you about the need for greater finances for community and legal centres, because we need the best lawyers representing people as best we can. And it's not just about giving them preliminary advice. Is it not about preparation of those affidavits that Mrs. R mentioned, and adequate and proper legal representation to equalise the power imbalance? I'll put it to you generally. Would someone like to respond?
Thank you, Senator.
Oh, sorry, go ahead.
I'm a federal MP, not a senator.
Okay, sorry, apologies. I think that's an excellent summary. I think you've understood our position really well. And what we're seeing a lot of is women who had a business, who owned their house, losing that business, selling their house in order to pay for the constant call back into the court. One of the ways in which the violence is weaponised and the court is weaponised is that there are constant calls back into court to justify this, to clarify, as Emma mentioned, the directions, orders, or what this actually means. And so, you know, I think there's a public perception that there's 2 or 3 key points. One is you go to a lawyer and you get some advice. Second is you do a bit of work and go to court. And then third is the orders are interpreted. That's it. Well, that is so far from the truth and from the experience. If that was it, there's a lot of women who could manage that funding. And there's a lot who can't too. I'd point out that the single mother-headed family is currently in Australia the family type most likely to live in poverty. And in part, that's because of family violence, leaving with nothing. I'll leave it there to let others have a say, but I absolutely agree that the way we have structured the legal support system is hugely damaging. I also want to point out, because there is no First Nations person on this panel, that a lot of the First Nations single mothers tell us that they go to an Aboriginal legal service, perhaps for help with the family violence order. And then when they are called into court and they go back to the same legal service, which is in their region, in their area, they find that the perpetrator has got there first and claimed the right. And so the service itself says, we are conflicted, we don't have enough resources, we're really sorry, we can't represent you. So there's a very broad, and that, by the way, also happens in where there are lawyers and limited numbers of lawyers who speak a particular language. There's a real battle to have enough services there. So I think the question of good, affordable legal advice for everybody across this country in relation to family violence and family law is a major issue.
Thank you, Ms Sebastian, and we will be taking evidence later today from First Nations representatives. I'm going to go to Kate Cheney. Ms Cheney, I can see my voice is going.
Thank you, Chair. Thanks very much. I'd love to hear more about the idea of having a MARAM-type risk assessment tool in the family law system. So just maybe some context about how that would work and how it would apply differently in the family law system to the police system and what the benefits would be. I don't know who that's directed to.
I'm happy to speak.
Ms Cheney, you go, Emma.
No, I'm happy to talk to it, but if you want to go first, that's fine.
And I will just point out that we do need to move quite quickly through the material. But yes, please, Ms Hassar, I think Ms Bevan.
Okay, so the MARAM, which has been rolled out in Victoria, is incredibly successful. I'm incredibly jealous that they have it and no other state and territory uses it. Does everybody know what the MARAM risk assessment framework is, or everyone's familiar with it?
Maybe give a couple of sentences. Yeah.
Yep. So the MARAM framework is the multi-agency risk assessment management framework. And what it does is provides almost like a questionnaire So in the same way that we assess risk for heart attack, we ask a person their diet, their lifestyle, their family history factors. We do a very similar thing with the MARAM. We look at access to guns, their specialist training, if they were, a police officer or in the military before that attracts a certain weight. And from those tools, we're able to assess the risk. There's homicidality that is able to be assessed by that risk, and there's also the risk of that perpetrator continuing to perpetrate. So in the men's behaviour change space, we have about 10% of men who are stubbornly never going to change, and the rest they talk about as being rehabilitatable, if you like. So the MARAM framework identifies quite clearly who the perpetrator is based on a pattern of behaviour and a pattern of access to things which they can continue to use in those processes. Now, if we used, a risk assessment tool that is similar to MARAM in the family court, again, it would really come down to how the court culture was to interpret it and how much weight a judge or a judicial officer was prepared to actually give to these things, because I know that those tools have been those evidences have been handed to judges, which have been routinely ignored because there is no consequence for how much weight these things attract in the family law court. They have to consider it, but they don't have to give it great weight. But if during intake of the family court process a risk assessment was filed, I believe that would give the judiciary a great deal more, and certainly those report writers, a great deal more access to identifying correctly who the perpetrator is, because our submission and certainly the oral submissions given by Ms. Sebastian talk about the misidentification of those people who are abused, because abused women can come across as quite neurotic. They can come across as quite stressed out and hostile and defensive, but having that tool would perhaps provide some greater insight. But again, we go back to that culture of the court and how those things are considered.
And so would the MARAM tool, could it be easily translated over to use in the family court, or would there be the need for the development of a more focused tool for family court purposes?
I think there is a case for the adaptation, but with some increased questions. So the MARAM as it stands now is quite short and quite not simple, but it is. There is one in New South Wales and there's one certainly in WA. But certainly I think that it could be expanded, and the multi-agency response and training would then be offered to the judiciaries and the family court system.
So the way it would work is as part of the same.
Can I just ask Ms. Bevan? I can see that you've been wanting to add to that as well. I thought I saw you indicating.
Yeah. I'm sorry to interrupt. I think just on the point of adaptation, what I would say is the MARAM is well received. It hasn't been adopted nationally, and like always in our state and federal jurisdictions, there's always a lot of conversation in relation to that. I think that as a baseline, we would probably need to adapt a tool to the specific job of the family court. But what I would say is 80% of matters before the family court have identified family violence issues. So this is core business. So we should absolutely be considering how do we both resource our family court actors, all officers and staff, and particularly those who are the decision makers, how do we make sure that they have material that makes sense in the context that they're working in, but also recognises that this is core business. This should be a requirement. I note that, currently in order to get access to the Lighthouse Project and then into the Evett list, there is a tool that women can fill in online that identifies their concerns. there are limits to that, and I think it requires a very active litigant to go into that and actually put their hand up and say, I'm at risk. So something that is more standardised, that is entry level for everyone, I think there are some benefits to that. I think we would have to consider it more broadly, but Ms. Cheney, I think as a sort of fundamental piece of work that informs the work of the court, there are definite strengths to that.
And I guess there'd be challenges with the evidentiary burden of the factors in that. But could be some role there of a more formal assessment process for the court to consider. Thank you. One more question, or maybe two more short questions then.
Yes, if we could have shorter answers, that would be very much appreciated.
I'll leave it to one. What do you see as being the role of lawyers in ensuring that the family law system isn't weaponised? Because obviously the lawyers have a duty to the court that the processes are used appropriately. And as you had said, Ms. Hassar, everything's dragged out to increase cost is potentially a conflict of interest, or a misalignment of interest with lawyers who are earning fees, but also ensuring that systems are used appropriately. How much of an issue do you think that is, and should lawyers have more of a duty to ensure that they're not abused?
It's a huge issue. I want to jump in on this because one of the particular ways in which we see lawyers enabling the abuse, and I refer in our submission, there's some case stories, they constantly tell mothers that the things your children are saying are being done to them is not relevant, it's too small, like basically they want the child hospitalised before they will even proactively support the case in court. So there's very many ways in which we see them as enablers. Too often, rather than, preventing that. And I just needed to say that. I'm sorry, I know we're short of time.
I think a cap on fees or a framework around what is able to be charged in the family law system is probably long and well overdue. I think that family law lawyers probably amongst some of the best paid lawyers in the country. And just to give some context, 9 years in the family court, $400,000 later, I sued someone in defamation. It took less than 12 months and it certainly didn't cost me anywhere near that amount of money. So, a family law proceeding that drags out for 9 years is by nature of that dragging out over 9 years is going to cost someone a lot more money. The court is inefficient, which adds to the fees, but also family lawyers are charging a lot of money. And the process is to keep the hostilities by and large alive. There is certainly no benefit for them to settle or to wrap up cases quickly. I wanted to just touch quickly on the Everton Lighthouse list. Kate, you asked a question and Karen, you spoke about it. The Everett list and the legislation around that, and this I guess goes to your point, Shane, as well, about the changes. The Everett list and the information given to intake officers during that lighthouse phase is not allowed by legislation to be considered in family law matters. So if that lighthouse the lighthouse program was to take or undertake the MARAM, keep in mind the current legislation does not allow for the judge to see, hear or cite any of the information given to a lighthouse intake worker, which I think is an absolute disgrace because it is another system that is just re-traumatising to the victim.
May I just very briefly add something? I'm so sorry. I know that we're already over time.
No,
but
please
I just
do.
wanted to thank you so much. I just wanted to add, you're absolutely right, Ms. Cheney, that lawyers have duties to the court. But the reality is that lawyers are not experts in family violence, and many of them don't have expertise in family violence, its dynamics and its impacts. So what we really need to see in the family court is much more of a risk and safety lens around decision making. And one way that that could be done is by increasing sort of joint support between lawyers and social workers. Women's legal services provide that support to some victim survivors of domestic and family violence going through the court system. What we really want to see is more of that expertise incorporated into decision making.
Thank you.
Can I just add? I want to. I've seen in recent victims that we advocate for that there seems to be a push to have a huge legal team right off the bat. So that's a barrister for the first mediation, a head solicitor for the first mediation, a legal assistant for the first mediation. And that's a small legal team, really. So there just seems to be this desire for this system to have these huge legal teams that cost exorbitant amounts of money. There are cases where it's 6 figures already and they've only had one mediation session and an interim hearing. That's ridiculous. As a victim of domestic violence, to be looking at a bill like that, it's honestly blows my mind. And I honestly don't know where the desire appears from. I think a victim of domestic violence looks to their legal team for support and assistance, and that legal team then just, drives up fees without possibly considering whether there's a need, particularly if they think that there's a giant asset pool that they can pull from. So I think a cap on fees would be quite good. I also see, and I've heard recently, that community legal centres or law firms that are on the list for legal aid and approved for legal aid actually don't want to take family law cases because it's a considerable amount of work and they only get one flat fee for a session or something like that. So there's a limit to what you can get when you don't have the funds. There's just such a huge contrast between the different experiences in the family law system when you're trying to get a legal team in place as to whether you have funds or you don't have funds. And I think that is something that also needs to be addressed.
Thank you. Now, I know Ms Miller-Frost was on the list to ask a question. Are you
I'm happy
to let it go? Thank you. Thank you very much. Look, thank you all for your evidence. I know some of it's straight outside our terms of reference, but it does provide context. So thank you very much. You will be sent a copy of the transcript of your evidence and will have an opportunity to request corrections to transcription errors. Please send your responses to any questions taken on notice during this hearing to the Secretariat, and I note there were a couple of offers to do that. We will now take a break and return at 12:05. Is that all right for those who are in the building? We're running a tiny bit behind time, but we don't want to start too late. Our next witnesses have appeared. So thank you all very much. I now welcome Family and Relationships Services Australia, and Uniting Vic Tas to give evidence together as a panel. For the Hansard record, would you please state your full names and the capacity in which you appear before the committee? Well, I start here with Dr. Clough.
Yes, thanks. I'm Dr. Robin Clough. I'm Manager of Policy and Research at Family and Relationship Services Australia.
Hello, Chair. I'm Jackie Brady, and I'm the Executive Director at Family and Relationship Services Australia.
Good afternoon. My name is Nick Tebby. I'm the National Executive Officer with Relationships Australia.
And online we have... Yeah, turn off the mute. Oh, no, it's on mute still. I think you've hit mute. Uniting Vic Tas. There we go.
Now, how's that?
That is beautiful.
That's good. Yes, good afternoon, Chair and committee members. My name is Bronwyn Pike. I'm the Chief Executive for Uniting Vic Tas. And my colleague?
Good afternoon. My name is Amanda Exley. I'm one of the senior managers here at Uniting Vic Tas.
Thank you very much for the hands... Oh, I've done that bit. Although you are not required to give evidence under oath, this hearing is a legal proceeding of the Parliament and has the same standing as proceedings of the House. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. When our Deputy Chair is just back in his seat, we'll introduce us. But would any of you like to make a brief opening statement before we go to discussion?
Yes, we've got one prepared, if that's okay.
Thank you.
And,
I do as well, yes.
So thank you, Chair, and other committee members for the opportunity to provide evidence here today. I'd like to start by acknowledging the traditional custodians of the land on which I join you today, and I pay my respects to the Ngunnawal and Ngambri peoples. I acknowledge and respect their continuing culture and the contribution that they make to the life of this city and this region. Family and Relationships Australia represents over 160 members with 135 organisational members directly delivering family and relationship services across Australia. These services include family law services that are funded through the Attorney General's Department and provide family dispute resolution, family law counselling, children's contact services and post-separation support services for children and for adults. These services help approximately 150,000 people, so that's children and parents, and grandparents in some circumstances each year. And I note that our members do work daily with families experiencing family violence. Over 6 years ago, we did survey members who provide family law services on their experiences of responding to family and domestic violence in family law contexts, and the survey found that most respondents, that's 75% of them, did report that violence was present in 60 to 80% of cases at that point of intake. And since this time, members have anecdotally reported an increase in the numbers of people presenting with family and domestic violence issues. And the other issue is client complexity when there's comorbidity factors that are in place. And I make that point because quite often there's a myth about family law services because we sit outside of the court systems that we don't deal with people presenting with family violence. Sadly, they are very, very strongly represented in the mix of people that we're working with. Since providing our submission to the committee in July, we've held further discussions with our members to unpack the point of intersection between the family law services delivered by our members, and we thank the committee and the Secretariat for allowing us to submit a supplementary submission. I should explain, as a peak organisation, it takes a bit of organising to get to our members, and sometimes the time frames are a little bit pressed for us, so thank you for that. But I will outline a couple of key points raised in that additional material here. Firstly, the voice of the child. FRSA consistently reiterates long-held concerns about how infrequently the child's voice is considered in making parenting orders. Our members delivering children's contact services reported that too often they are seeing children at their services where the court has ordered supervised contact, yet the child does not want contact with the parent due to abuse and violence. Recent amendments to the Family Law Act that aim to prioritise children's best interests in the family law system, including the removal of presumption of equal shared parental responsibility and shared time provisions, will, we hope, go some way to ensuring that appropriate parenting orders are made in the best interests of the children. In our view, however, the legislative amendments are not enough. We consider that within the court context, there should be a new role, a children's advocate with skills and understanding in child development, trauma-informed practice and working with children to enable child participation in decisions affecting them. We also add that we would like to see greater investment and funding of child-inclusive practice within our own services to ensure that the child's voice is appropriately represented where necessary. In terms of safety risk, our members work daily with clients impacted by family violence, as I've said, but in doing so we undertake comprehensive safety risk assessment with all people accessing family law services, and also add that risk assessment is ongoing. It's not just done at the beginning, it's just bread and butter of services. It's central to our work given the prevalence of people, children and parents who have experienced or are experiencing family violence. At present, services delivered by a family law system are not part of the information sharing or the federal government's information sharing scheme, which we believe needs to change. Our ability to receive information as to whether there is an FVO in place or a matter of child protection should not rely on self-disclosure. Access to this information would enhance our risk assessment processes. As was reflected in our submission and in the submission of others to this inquiry, the Federal Circuit Family Court of Australia's relatively recent introduction of risk assessment process known as the Lighthouse Project is to be applauded. Risk assessment in the court is currently voluntary, however, and our view is that safety risk screening in the family court context should be mandatory in the way that it is in our own family law services. Our members delivering the children's contact services observe that it's not uncommon for families directed by the court to attend children's contact services for their intake and assessment to be the first time parties have actually been asked questions about their risk. The other aspect that we believe there's an opportunity for greater knowledge sharing between our services and the courts, and this is underpinned by strong relationships that we believe should be built there. Our members would welcome the opportunity to further share with judicial officers and other legal professionals how family law services operate, the opportunities they offer to clients and the limits. This may circumvent unsafe referral processes, such as high conflict parties being court ordered to family counselling when it's not safe to bring those parties into the same therapeutic environment. In closing, I note that while providing better access for victim survivors to family violence orders may contribute to the objective of a safer system, this will only be realised if other appropriate supports and practices are in place. Importantly, the risk of systems abuse must be mitigated and greater priority is given to early intervention. It's vital that victim survivors of domestic and family violence have access to social service supports as well as legal protections. So thank you, and we welcome the opportunity to answer any questions.
Thank you. Mr. Tebby.
Thank you, yes, and thank you, Jackie, for your acknowledgement. On behalf of Relationships Australia, I'd also like to acknowledge that we meet today on the lands of the Ngunnawal people. Relationships Australia is a federation of community-based not-for-profit organisations and a member of FRSA, so much of what Jackie said relates to our practice experience and those of others across the sector. Some of our services across our federation include services for victims and perpetrators of domestic, family and sexual and other interpersonal violence, including abuse and neglect of older people and children. We aim to support all people in Australia to live with positive and respectful relationships, and we believe that people have the capacity to change how they relate to others. Our services include, relevant to this committee, specialised family violence services, services designed for men, including programs to support parenting capacities and men's behaviour change programs and other perpetrator interventions, as well as family law counselling, mediation and dispute resolution, and post-separation services for parents and children. Domestic and family violence is a serious and highly prevalent problem among our clients. Through our work, we see that DFV is not a discrete phenomenon. In fact, it's often accompanied by a constellation of interacting comorbidities, including harmful use of alcohol and other substances, gambling harms, mental health problems, and personality disorders. Equally, we see all too often the challenges that our clients face when they're seeking safe and supported resolution of relationship issues, whether that be by way of seeking an FVO or progressing their matter through the family court, or, as we hear in many cases, both. We believe that we see that this includes a range of difficulties navigating the complexities and fragmentation of the system, fear about heightened risks of escalation of DFV, and a lack of the social supports that are needed to help people overcome, recover and thrive beyond that period. We have welcomed the recent reforms to the family law system, including amendments to the Act that seek to reduce the risks to victim survivors, including the exploitation of opportunities presented by legal proceedings to perpetuate abuse through systems abuse. We also welcome the greater focus on the best interests and well-being of children through those amendments. However, significant risks still remain. And for this reason, Relationships Australia has made a number of recommendations in our submission, which we believe will help to ensure the safety and well-being of victim survivors and support the aims of the National Plan to eliminate violence against women and children. In particular, if I can draw the committee's attention to some of those key recommendations, the first is that information sharing and National Domestic Violence Order Scheme should be extended with appropriate safeguards to allow service providers to access orders that are in place. We need to end a system whereby service providers are operating in the dark, often having to seek information from people who at best don't understand it and in some cases don't even know that there are orders in place. We see the need to reduce the burdens of fragmentation on victim survivors by empowering and resourcing the Federal Circuit and Family Court to make FVOs. And we see the important need for post-order and post-agreement services outside of the often distressing court setting. These should be made available in accordance with the principles of geographic equity and universal access. Thank you again for the opportunity and very much look forward to answering the committee's questions.
Thank you. And Uniting VicTaz, would you like to make an opening statement?
Yes, thank you very much. I'll just make a few brief comments about our interest in the work of the committee and why we thought it was important to make a submission. We join you from Wurundjeri land here in Melbourne, and Uniting VicTaz is the largest community service provider in Victoria and Tasmania. We have around 650 separate programs and we deliver services right around the two states. We do have a very strong focus on family violence services. We're the partner in 6 of the Orange Doors, which you will be familiar with, is a sort of access point for children and families seeking support. But we are also the lead agency in the National Escaping Violence Program pilot, which has been underway, and you will be familiar with the program because recently the program has been made a permanent feature of our support system in the last federal budget. Since its commencement in October 21, we've supported 60,000 people with packages who've been leaving family violence situations, and of those 60,000 people, 80% have had no former contact with any other parts of the support system, whether they be legal, whether they be specialist family violence programs, etc. So we have a very rich source of data and insight in being the lead agency for the consortium that's been delivering that program. And of course, as you've heard, family violence is really the common denominator for all of the entry points and service systems that we offer, whether they be homelessness or obviously people in the child protection system, out of home care, financial counselling, the whole mental health, drug and alcohol, all of those all of those service points, there's this overarching common denominator that's always there or nearly always there. For many of our consumers, engagement with the family court is very scary. It's very overwhelming. It's often an unsafe experience, and our workers certainly find themselves walking alongside victims, survivors. So we really come, from a practice lens, and very happy to provide any additional information that the committee may require. And Amanda might add a few more comments too.
Thank you, Bronwyn, and thank you to the committee for enabling us to be a part of this really important inquiry. So as Bronwyn has outlined, Uniting works with families and children in a range of diverse service settings across Victoria and Tasmania. Our child wellbeing focus is woven through our family services, and we bring that lens to the inquiry and really feel that that's an important aspect of what we are here to speak about. We want to emphasise the importance of bringing children to the front and centre in our responses to family violence, and this includes how we respond to children in the family court setting. Our frontline practitioners see the devastating impacts when the wellbeing of children is not the priority. A trauma-informed care and lens is often missing in our legal and justice systems and processes, and we really do need to highlight the 5 principles of trauma-informed care of safety, trustworthiness, choice, collaboration and empowerment. And our teams live through this every day with the work that they do with our frontline practitioners and our consumers and the expertise that they each share in that journey. Our family court system is often difficult for our victim survivors to understand and to navigate, and we're often told that this is really burdensome and it's extremely overwhelming. The family courts and state-based child protection and justice systems often operate in isolation from one another, and making it even more complicated for families who are struggling. And we really want to be able to support that and take away some of that burden. Sharing information about risk and applying a consistent understanding and response to family violence is also often absent. For these reasons, our key observations and recommendations to the committee centre around the need for children to be recognised as victim survivors in their own right, and I feel that there's a common theme of that today from the other panel members. Addressing the way perpetrators use the family court process to continually coercively control and perpetrate abuse. Ensuring consistent understanding of the prevalence and seriousness of family violence and embedding processes to address family violence risk in the family court setting, and creating a family court system that is trauma-informed. Before I finish, I'd like to share a quote from one of our senior managers that aptly speaks to the heart of the issues that we see. "I think sometimes we make it more difficult than it needs to be. At the centre of this are families and children, and we put these complex systems, processes and rules that no one really understands over the top of their experience. It just adds to the vulnerability of the family at the time and the utter confusion in what's already a really traumatic time. These systems are meant to be supporting families and children, but in many ways they just make it overly difficult. We really need to ensure that individuals are treated with dignity and respect and ensure the physical and emotional safety and well-being of our children and young people, without sacrificing the security of the formality of the judicial proceedings." We welcome any questions that you may have and happy to pass back to yourselves. Thank you.
Thank you all very much, and thank you for your submissions, which have been really, really good to read. I'm going to ask a sort of broad question of that for each of you, or those of you who'd like to respond, that really goes to the heart of our terms of reference, and that is based on the feedback from clients or from your organisations that you're representing. Of those who are going through the family law system, do you see that they experience increased and escalating violence once those proceedings have commenced? And I'm also interested in whether they have domestic violence orders in place when they come to you, or based on what the members of who you work with are telling you. So I don't know who would like to start in sharing Dr. Clough, you look like you'd like to start.
There is something I'd like to say, and I guess, you know, there's been plenty of evidence today even and plenty of research that talks about the fact that court proceedings are, you know, there's a point of escalation there. And I think what I'd like to say is that we're also seeing that at other points in the family law system. So there are only 3 to 4% of separating parents are going through the court, and it's really important that family violence, etc., is managed in those situations. We have, I think, about 10% of separating families, 9 to 10%, going through family dispute resolution. Many of those will be experiencing family violence in some form. Some of them will have family violence orders that have provided an exception for the separating parents to undertake mediation. One of the points of escalation that our members have raised with us is when a family violence order is made and there's an exception for mediation, the time between the family violence order being made and them actually being able to access family dispute resolution may be, you know, several weeks, depending on the wait list of a particular service. Ironically, perhaps, the family violence order, it can be a bit of a trigger in itself, in that often when those orders are made, until mediation occurs, there is no contact between the perpetrator parent and the child. That can be frustrating for them. They can feel like the other partner is having some power over them and preventing them seeing their children, etc. So it can actually escalate the risk for the protective parent and the children. And so in those circumstances, what we would really like to see is some way to expedite those cases, and that could be by having a family dispute resolution practitioner co-located in the local courts when family violence hearings are taking place, and have the opportunity to make some kind of interim arrangements with both the parents, just to try and keep that anger, etc., under control, or more funding to be able to, within the context of a family dispute resolution service, to be able to expedite cases where there is a family violence order in place. I think more information sharing would assist in that process. So family dispute resolution services being able to, I guess in real time, have access to a kind of family violence order registry or child protection concerns, that kind of thing.
I think the only other point that I'd make is there's no doubt that the actual engagement with services or with the courts certainly heightens people's emotional state and risk factors. But the one that's well documented is the fact that separation itself, so relationship breakdown, is actually the risk factor that is most prevalent, I think, in the literature. And so it's the engagement with court that then, I suppose, takes that or you know, brings it up to another level when it's going through that process. But it's actually relationship breakdown itself that is an issue. And I think one of the other things, and I know that we haven't referred to it, and Robin will have to catch me up on the figures, but when we look at, say, this the child maltreatment study and the survey that was conducted there, the prevalence of young people that go through the family court system or who have been through family breakdown, who are experiencing family violence, the corresponding sort of nature of going through relationship breakdown and experiencing family violence is very high. And that's what the child maltreatment study has been able to show us as well. So I think that when we talk about a prevalence of risk, it is about the relationship breakdown, not just the engagement with the court system.
If I can just add, I think our practice experience absolutely supports what Robin and Jackie have said, that is a point of potential escalation. And certainly there are clients within our services who already have FVOs or who are going through that process or need to go through that process. But I think just to pick up Robin's point about the services that are provided in the dispute resolution and the family relationship centre sector is that they often extend beyond just working on the separation or resolving that part of the relationship. And the idea of having people at a point where ideally as early as possible when these issues are being identified, they have access not just to counselling and dispute resolution, but to the wraparound services that can be provided. So those include services specifically for the children who are often not seen as victims, but certainly are victims in their own right, but also therapeutic services for victim survivors, and of course, importantly, perpetrator interventions. Part of our service offering is to make sure, no matter what the reason a person walks through our doors, we identify a full range of risks and the comorbidities that person might be experiencing, and make sure the referrals are made, whether that's internal to other parts of Relationships Australia or within the broader network. Because often people are not in a place to be able to resolve, their separation until these other issues are addressed, and that can range from obviously mental illness, addiction, housing precarity and homelessness, and of course family violence is there amongst all of that.
And timeliness is obviously a critical issue here because, many of our families don't even access the family court when they need to and could, because the prevalence of family violence in their own situation just interferes. So it could be coercive control, it could just be the complete chaos. And so the longer the process takes, obviously, the more the barriers are there and people's access to justice is inhibited. Amanda?
Yeah, so up to 50% of our court-mandated counselling order programme clients have also involved with family dispute resolution at any one time, and it's very, very difficult for those victim survivors that they're constantly being re-traumatised, the complications of the family violence recovery, not only for the victim survivor as an adult, but for children and the young people as well that might be involved. And what we also need to consider in that is that for that trauma-informed lens, the men that really need to have completed that men's behaviour change programme or be, close to completing that for there to be any sort of understanding, being able to move forward with actually what's going on in that family home at any one time, and just the anger and wherever else that they might be, and trying to meet that need and support that need to be able to get them to where they need to be.
Now I'm going to hand over to Mr. Newman to pick up from there.
Thanks very much, Chair. Some years ago, the Family Law Act was changed that requires a person to make an attempt to resolve disputes about parenting matters through family dispute resolution services before applying to a court for a parenting order. Now, in the submission by FRSA, there's some talking about many of your members providing family dispute resolution. There are exemptions, aren't there, under Section 60, subsection 9 of the Family Law Act to those compulsory, family dispute resolutions before. But the evidence that comes through your submission, and we've had evidence today, is that people often feel traumatised by putting themselves through those family dispute resolution procedures. And I'm wondering if, in our attempt to try and resolve cases before they get to court, we're actually re-traumatising people by almost making them go through those family dispute resolution proceedings beforehand in circumstances where there's an unequal power imbalance, no legal representation. And on the evidence that you've given, there are so many family violence cases that are being directed to FDR. Why is that the case? Then should we have a look at that? Should our system be looked at again? And should we review as to whether that is actually the right thing to do before proceedings are instituted?
Thank you for the question. I'm just sitting here thinking about Dr. Rachel Carson's evidence to the inquiry this morning, where there was reflection on the fact of people who had engaged with the FDRP process or family dispute resolution actually did speak favourably about their experience of that engagement. And I think the strong point about family dispute resolution where it exists outside of the court system is that it's less adversarial. Now, that's not to say that it couldn't be enhanced by having legally assisted FDR. We've certainly advocated for that in the past, that having legally assisted FDR can be beneficial, particularly in family violence cases. But I think we would still advocate the point, and I think that the literature does lend itself to the fact that there is, strong evidence to suggest that engaging in FDR process out of the court does resolve in better outcomes for the families in the longer term, so that they are part of that decision-making process rather than it being a judicial decision that's handed down to them. So the whole idea of dispute resolution is, in fact, to try to get the parties to see what is in the best interests of the children, because that's really where it's emanated from, is that focus on best interests of the children. And so, for them to both agree to that point is where essentially the skill of the family dispute resolution practitioner is intended to lie. So I think I would still advocate the fact that it being less adversarial is strengths-based in the system, but that's not to say, certainly there can always be room for improvement, I suppose, in any system, but I certainly think that it being outside of the court is its strength.
So your advice to us would be leave the system in place with the exemptions that are there, like the Hague Convention cases, the urgent applications, child abuse and domestic violence, but equalise the power imbalance by allowing legally assisted processes and early FDR arrangements that could benefit the parties but reduce that power imbalance. Is that your evidence?
Well, it can enhance the information that's provided at the point of FDR. The exemptions, I suppose, that still apply to the FDR process in so far as any presentations, say, where there was child abuse would directly go to the court system. So I think that there are decisions made through the FDR process about whether mediation is safe and whether it is of best interest for the children, and whether it's suitable given all range of risk factors that may present themselves through the risk assessment process and the initial FDR engagement. So the fact that it sits pre-court also means that some of the exemptions that are stipulated in the legislation are more specific, I suppose, to the court environment too.
Have you received any feedback? One final question, Chair. Have you received any feedback from your clients who've gone through that Section 60, subsection 9 process, the exemption, where they have to provide evidence of what was available in terms of FDR and locally, as well as the fact that they have now articulated that they shouldn't have gone through that process, didn't want to go through that process? What's been the response? Have they any feedback to you about that after they go before a court? Is the court accepting that exemption? The court accepting that exemption on a regular basis, or are they saying, yeah, you shouldn't be here. You should be going through the FDR process before you came here?
We might comment. We've got client experience in this, yeah.
Yeah, so not everyone in Victoria can access FDR. It's previously been means tested as well for clients to attend, and that would depend on how financially viable that was for someone to actually access those services, particularly in Victoria. I'm not sure what that looks like sort of nationally. And for us as well, often the perpetrators will hold up systems and drag that out for as long as they possibly can as well, by either not attending. There's lots of reasons why that obviously happens, but that really doesn't help in moving through a support system when the perpetrator is not willing to meet and be able to work through that process because they'll constantly just miss appointments.
And my point, Chair, is that this process can continue to be used by perpetrators to continue that abuse prior to
Absolutely.
the institution proceeding.
That's our experience.
The coercive control continues on, and that's what we're hearing from our consumers on a daily basis. That it's used as a weapon, as a barrier, as a way of demonising and continuing to withhold and actually control, and that's what it's all about.
So what's put in place for really in the best interest of litigants, potential litigants and children can be weaponised by perpetrators. So we should have a look at that perhaps and see whether in fact
Absolutely.
that needs to be reviewed.
Yeah, and that's not to say that, we all kind of want things to be resolved amicably, but and that's a high value policy outcome. But the risk frameworks do have to be very robustly applied, and a recognition of what is actually happening for those very high risk families.
Yeah, not to denigrate or derogate from FDR, but to see if we can improve it.
No.
Yes.
Mr. Tebby would like to add something to
Sorry,
that.
yes, I'm jumping out of my seat too. There's a few points I'd like to come back to, but maybe just to make a point around that last point around weaponisation first, in that, there are risks inherent right across the family law system, and particularly, we see, and I'm sure, I know you've had evidence of how the courts are weaponised and processes within the courts are weaponised as well. So I think presenting the court as a solution to avoid some of that risk is actually not helpful to the bigger problem.
Well, I'm not doing that.
No, I know, but I'm just hoping we'll avoid that, because I think what we see through our services is that absolutely there are situations where the risk is too great to go ahead with a supported FDR, whether lawyers are involved or not. But there are, as you've said, Mr. Newman, there are opportunities within the Act to move those matters out of FDR as quickly as possible. So I think, to answer your question, yes, the system is there. I think what's needed is greater training and education around how those processes can work and a better lining up between FDR and the courts. But I just want to point out, to come back to your first question, that, it's often made, the comment is often made that FDR is not at the coalface of family violence and perhaps is a risk of family violence being continued and perpetuated. But actually, that undermines and diminishes the expertise of that sector. I think as a sector that is highly trauma-informed and has highly specialised workforce who, as I mentioned earlier, provide a whole range of wraparound support services. So even in a situation where perhaps FDR is not appropriate and referrals need to be made, often what we will do with those clients is provide the counselling and other therapeutic supports that will then support that client to work through those other processes as well. So there's actually a great benefit in seeing those clients as soon as possible, as early as possible in the process, and not waiting for a matter to languish in court waiting lists and things to happen in the family court down the track, where that risk just goes unmitigated for that period of time. So I think there's an importance to see the co-equal nature of both FDR and the courts in addressing this issue.
No, I agree. I've got to go, Chair. As long as we can equalise the power imbalance.
Sure.
Thank you. Thanks, Mr. Newman. I'm going to hand to Ms. Miller-Frost.
Thank you. Family Relationships Australia, in your submission, you talked about two options for reform, a co-location model and a federal family violence order model. Can I get you to explain what these models are? I'll leave it there for the moment. So, what did you have in mind for those two options?
Look, to be honest, I don't think we had anything in mind. So it was a question raised in the terms of reference about co-location, and I think our response was, on the surface, that sounds sensible, like it's terrible for people who are already vulnerable to have to kind of, access multiple courts, etc. It is not our area of expertise, or not where we sit by any means. And having looked further at submissions since making our submission, it would seem that there are quite a few practical challenges there in either models, in fact. But I think probably the point that I would emphasise from our submission is that where we think attention needs to be focused is actually on supporting people to be able to apply for FVOs or seek other family violence supports that they need, rather than kind of, I guess, worrying so much about, you know, where is it co-located or are there federal family violence orders? It's actually people who are in court being able to have, so there's the family, I always forget, the FAS, Family Advocacy and Support Service program running in the court. We would like to see that expanded so that it's offered to people accessing, in family court in every registry, because that is where you do get that support for those parties to be able to, go and, help information, I guess, and support on being able to access a family violence order or being linked in, if it's a perpetrator, to a men's behaviour change program or whatever it is. So I think really our focus is more on information and support rather than tinkering with the sort of the legal mechanisms.
I'd also just like to have a conversation about what the role of the AVO or FVO is. We've heard from people earlier today that while perhaps the woman, the victim survivor, might get an FVO and think that that has established in law that the violence had occurred, that it's not being taken seriously by other systems. And we've heard about schools, about police, about parenting orders where the FVO kind of doesn't seem to fulfil the role that perhaps the survivor thought it might going through that process. And obviously the perpetrator is often not taking it seriously either. What do you actually think the role of the FVO is or should be? And is there some way we can actually make it have more teeth, more function within those other systems?
I think as a starting point, the role of an FVO is safety, right? And it should be viewed as what it was intended as, which is an urgent response to an unsafe situation. It's, someone only applies or has an FVO order made if that immediate risk is considered to be real and necessary. So I think it's not a final adjudication on a situation, but as you say, people often view it as such. What we need to do is improve the role of the FVO or what happens at the time that an FVO is made. I think the information sharing is really important. I think a family court that later comes to consider a matter needs to have full information around the existence of previous FVOs or applications for them. But I think what we're actually looking at is a missed opportunity at the time the FVO is made to actually enter and provide wraparound supports to the perpetrators as well as the victim survivors. And so one thing that I think is a really easy measure, at least in principle, is that if someone has an FVO order made against them as a perpetrator, why are we not then immediately reaching out to that perpetrator and saying, here are the perpetrator interventions, whether it's men's behaviour change programs or other things. Essentially an FVO order can be made in isolation without any consideration of all of the other issues. So I think we need to start saying that no, if that order is made, then certain things are triggered, including putting that person into a program of intervention. And I think that would be one really meaningful recommendation.
And would you see that as a compulsory referral?
Yes, I would. Of course, it has resource implications. The men's behaviour change system is grossly under-resourced at the moment, as we have been hearing, but it would be amazing to see if we could address the resourcing issue, mandatory referrals into some sort of, it may not always be men's behaviour change programs, it may be even drug and alcohol assistance and other things, but let's appreciate that person, the perpetrator, has the capacity to change, and that if we don't help them change, then an FVO is not going to stop them from perhaps perpetrating again with another family down the line, or again with the same family, as we've seen through escalation.
Thank you.
I'm not sure if uniting...
We might make a comment.
Yes.
So the experience that we have down in Victoria with the court-mandated counselling order program, in respect of what works and what doesn't work, there's a huge drop-off rate for those courses. Actually, long wait lists as well to actually get those men in there. And we actually need to be able to support someone at the time when they actually need that support and not be told they've got to wait 10 weeks, 20 weeks or whatever as well. And that's really important in actually recognising that stage of change that someone might be in at that time and point of entry. And so that's really complex. We've got to think about the importance as well of the perpetrator getting their direction and having that NBC contact, but also, is there other options to that? Can we do some one-on-one work as opposed to a group? Because we've got to think about cognitive ability as well of individuals, because not everybody can sit within a group setting. Not everyone has got that cognition, and we need to really think outside of the box around a more bespoke way of actually supporting and working with individuals to be able to support and enable perpetrators to be where they need to be at as well, and we kind of need to meet some of that halfway.
Thank you.
Thank you. Can I just look? Actually, I'll go to you first, and I'll finish up. I know you've been very patiently waiting there, Deputy Chair.
I apologise for being a few minutes late. My name's Pat Conahan. I'm a member for Calpa.
I forgot to do that. I said I would do that when we all got here, and I completely forgot to do that. So thank you, Deputy Chair.
I am the Shadow Assistant Minister for Prevention of Family Violence and also Social Services. And Ms Pike, I've met with your colleague Jeremy Pettit down in...
yes,
good. Yeah, so thank you for the wonderful...
In Tasmania.
Yep.
Yes, thank you.
Yep, wonderful job you're doing down there. Mrs Brady, I'll just start with a comment you made. One of the recommendations you would like to see a children's advocate. What's the difference between a children's advocate and an ICL, independent children's lawyer, and how would they differ in how they operate?
I think that the thing about the children's advocate, it is more of a social services or more of a social lens rather than a legal lens. So it's someone who's either a psychologist or a social worker or someone of that sort of background that would be essentially representing the views of the child and making those known to the court. So ICLs are, as I understand, whilst it's been extended now in changes to the legislation that there's now a requirement that the ICL must meet with the child. Whilst they can take into account what the child is saying to them, the information that they present to the court is actually their legal advice about what would be in the best interest of the child in the particular matter, whereas a children's advocate would be intended to really represent the views and the voice of the child to the court system. So whilst an ICL can take into account what the child is saying to them, the advice that they give to the court may not always necessarily reflect what the child themselves says that they want.
I'm just thinking of resources. Wouldn't it be easier or more effective and efficient for the ICL to provide a legal view, but also the views of the child, whether they're relevant or can be entered into evidence or not? We can't find those resources of counsellors, psychologists at the moment. Would it not be better to expand the role of the ICL?
I mean, I think that ICLs are already under enormous pressure.
Yeah.
I think, as Jackie indicated, they are first and foremost lawyers, so some of them are amazing at working with children, but it is not everyone's cup of tea, you know, and so the idea is that you would have someone who is specifically trained, has an interest in working with children, but also that the ICL role is very much one of evidence gathering. So the idea of an advocate is, I think that they're working a bit more kind of closely with the child. It would support the ICL role. And I appreciate what you're saying about the resources, but in fact, this was something that was raised in 2018 by the Australian Law Reform Commission in a discussion paper about this idea of a children's advocate. And then they on balance, decided that there were too many professionals in the system already. Well, in that time, I know that our members delivering children's contact services,
Sorry,
and
could you
Jackie,
say that again?
our members delivering children's contact services, and I think Jackie mentioned in her opening statement, are seeing more and more seeing children who have made it, do not want to see the perpetrating parent. They're frightened. And that is not being taken into account. So what I think is that it's really clear the system is not working, and if we actually want to keep children safe, then maybe it's worth us making that investment rather than going there aren't enough resources, because in fact there are always enough resources if we want something strongly enough.
Yeah, and that comes down to dollars and cents. Yeah, that's right.
Can we make a comment here? Amanda's got sort of experience from another jurisdiction that's been helpful too.
Yeah, so obviously the Royal Commission or the Victorian Royal Commission into Family Violence had some recommendations in there that recognise children in their own rights as victim survivors in family violence, and systems we've talked about the independent children's lawyers and what that might look like, and resourcing is very, very difficult. It might be that we need to look at that resourcing from another lens and another way of being able to bring in those kind of positions. For example, in the UK, they have the guardian ad litem system, where a child does have that voice, that it's set within the family court system. It's obviously then supports those often the children's rights over the parents' rights, and I think that's where we really need to concentrate, because we do forget that the children are a really big and important piece in this, and it doesn't matter what age that child is, we've got systems and ability to be able to actually work with children with those specialist roles. And I think as well that there needs to be a bigger investment in workforce and workforce retention and support around what does the workforce actually need to look like in the space of family violence, and being able to ensure that we do have the right qualifications, the right people that are doing those roles. And it's down to resourcing.
Yeah, thank you. I am kind of moving away from the terms of reference, but it's about what Mr. Tebby was talking about, and that is the wraparound services and support services for the perpetrators. And I've been fortunate enough to travel around Australia in my shadow role, and all the agencies are saying the same thing, that there's not enough funding for prevention and intervention, particularly for men's intervention programs. I doubt that I'm going to be shouted down by you or anybody in relation to that.
No,
absolutely not.
100% agree.
Yes. Look, it's a common, something that we are shouting, quite the opposite, shouting out, not shouting down, that more resourcing is critical. And I think for too long, successive governments have been afraid or cautious about funding intervention programs, because it's often viewed at potentially at the expense of support services for victim survivors. And we're very strongly of the view that you should not remove one to fund the other. I think that's very clearly accepted now. But it's our experience across our federation that even if we rapidly increased the funding and the number of available men's behaviour change programs and other perpetrator interventions, we would still struggle to meet demand. Yeah. In any one of our locations, I know in New South Wales, for example, we've got wait lists of 240 plus men who are there because either they've chosen to be or someone's told them they have to be, who are therefore at a point where they need to change, and yet then we have to say to them, well, no, now you'll wait. In some locations, we're funded through very piecemeal funding arrangements to maybe deliver one men's behaviour change program in this town once a year. And so I know that happens in northern Queensland, where Relationships Australia Queensland will come in and they'll say in a month's time we're going to be here to deliver this service. It fills up within an hour of it being announced. And then if you missed it, you wait a year before the next one.
I was just going to add the other point there is that at a Commonwealth level, there's very little funding provided to be able to deliver men's behaviour change program. At the moment, they're funded through the Specialised Family Violence Service, predominantly, which is actually not funded by Attorney General's Department, it's funded by the Department of Social Services. There was a bit of an increase, but I think it's somewhere between, say, $4.5 or $5 million per annum that's dedicated to that program. So the investment at a Commonwealth level is fairly limited, I've got to be quite honest and say. So there's plenty of improvement that could be made there. The vast majority of services that are provided men's behaviour change are funded by, because family violence does rest in the state and territory domain, does come through those avenues. I think the only other point that I'd make is that whilst there is limited funding, there is an opportunity to scale up because there is the expertise that sits within the family and relationship services system. The other factor that is, and taking Nick's point, and I've certainly had these conversations with frontline service providers, it's certainly not the intention to detract from there. But one of the things I think that's often lost about men's behaviour change program is core to their mechanism or the way that they operate is that they do keep eyes on the victim, on the children, and not just the current victim but the previous one as well, or previous partners and their children. So part of the men's behaviour change program construct is keeping the victims, survivors, in view of the work that is going on, because they acknowledge that working with the man or the perpetrator can escalate issues. So that's very much central to the way that program's delivered, to be quite honest.
Do you think there should be a national guideline created for men's behavioural programs? Because I've travelled around whether it's in a city, a regional area or very remote, some programs are being developed and may not be best practice. So a national guideline, you can. I don't want cookie cutter, but the principles there of how it should operate and who should operate them.
There's many organisations as well that are running a variety of different programs that extend outside of men's behaviour change programs. I think it's really important to note we specifically have a program that's funded by the Department of Families, Fairness and Housing by here in Victoria called Place for Change, and that specifically works with men who are on exclusion orders, and we've got a whole wraparound service that actually works with the perpetrator around keeping them in accommodation, looking at any financial issues they might have, actually supporting them with employment and other things, and then also doing the one-on-one case management around what's actually going on for them in that space and supporting any other program that they might have as well. And that's been a really successful program. It's been a pilot down here now for a number of years, but those kind of programs are ones that really, if there was additional funding, that those could be looked at to work alongside of the programs that are already in existence in support of the perpetrator, because that's where it starts. That's where the violence starts, and that's where we have to put that funding in at that end as well to be able to support them to stop that violence.
Thank you. Answer to your question, Mr. Conahan, absolutely yes. I think there are so many interesting examples of work, as we've just heard from Uniting, and right across the country of work that's been being done with perpetrators. And while the government, I think it was in 2015, published national outcome standards for perpetrator interventions, there's never been a comprehensive Australian study of what works and what would be the key defining principles. So if we had that, and I think a lot of research is being done, and earlier this year Anne Rose commissioned a range of research which we very much welcomed, because I think developing a better understanding through an evidence base will help us identify the sorts of projects nationally that can be scaled up and that do work. So I think at Relationships Australia we would absolutely welcome more attention to what's being done in the perpetrator intervention space, and perhaps I think today the rapid review is is publishing its findings, so there may be some more in that, we hope, that an opportunity to coordinate efforts around perpetrator intervention, as you say, not to say it always has to be the same, but to at least have an idea of what we're trying to achieve and how, would be incredibly beneficial.
And I think the other, if I may, the other point is that every point of engagement provides an opportunity for intervention, I think is one of the key messages. And so even in the family, we would say in the family law services system, you are working with often both partners. It may not be in the same, or both people to the relationship. So it may not be in the same room, it might be shuttle, one may be on screen, one may be in the room. But generally, if you are working in that FDR context, you are working with both parties, notwithstanding the fact that some get screened out because they haven't shown up and go straight to court. But it does provide a point of intervention that we can be ensuring that they are being referred to the appropriate supports and programs. And that's, I think, also the beauty of the family law services system is we are embedded within the social service system, and our connection then and our tentacles out into the broader service system is also there. So whether it's internal or whether it's external, we do sit within that social service system. So I think that again attests to the fact that the work that we do, if we can help the families resolve their issues and to find them the right supports at the right point in time. But it always does come down to resourcing, because there's always much more demand than there is availability.
Thank you. And just for anyone listening, I'd never suggest that we take away from the response and recovery, but we need to match dollar for dollar prevention and intervention. So I have 1,000 other questions, but I'll hand back to you, Chair.
Thank you. Well, we've still got a bit of time, but I think you made the comment that that might be slightly outside, but in fact, if those programs make it safer for women and children going through the system, then they are part of the solution. And I've been following I think it's called the Innovative Perpetrator Response Program, and I know there's several $1 million for trials. So there's trials around the country, and I think your point, Mr. Tebby, there hasn't been a lot to build on. So, I think there's very strong recognition by the government that there's work to do here, and the trials will be all different, and it will be interesting to see the evidence of what's effective in what circumstances.
And very bipartisan work.
Yeah, that's right.
And it was very good to see that in the National Framework for Ending Violence Against Women and Children, that we did see the men's behaviour change programs as a key pillar within that scheme and within that system, because it does certainly acknowledge, that there is work to be done in that space. I think some of the main changes in the men's behaviour change were a number of years ago where Professor Cathy Humphreys was doing some work. And one of the major shifts, I think, in the group programs was that where they moved from a 12-week program to a 20-week program, acknowledging it takes much longer to work through that program system. But notwithstanding the fact, as Uniting says, there's other interventions that can be possible to work with men that aren't, and not all men will be suited to group work and activity. But there's men's counselling. There used to be a specific men's family and relationship counselling program that no longer exists. So the acknowledgement is there that we need to be working more with men in a concerted fashion if we're going to address the gendered nature of family violence.
And I do note that one of the trials in particular is around family violence orders, and it's a Tasmanian one, and we should be commending the Tasmanian government for partnering on this, and that's about men attending, it's court mandated to attend a rehab program as a condition of a family violence order. So look, I think we really hope to see some way forward on those things.
But we do need more evidence. We do need more evidence because the dropout rate's about only 50% complete the program.
Now, can I go back?
Existing programs. Yeah.
Can I go back to sort of a basic bit, and I might direct this in the first instance to Uniting. When people come to you and don't have a family violence order, is it something that you sometimes encourage them to do? And if so, where do they get support to do? What support do they actually need? What are the practical things they need if they haven't already got it to get that?
Yeah, sure. So we have the orange doors down here in Victoria, and that's obviously for family violence and child wellbeing. But what we have found within that data is that families that are coming through into the orange door often feel a lot safer to talk about child wellbeing issues at that point of referral. And so it may come through then into the family service teams. And whether it be 1 week, 2 weeks, or a month down the track, we're actually finding out that family violence is interlaced between what's actually going on. But it's at that point of feeling safe to be able to further disclose that, because at the point of entry into Orange Door, it's often not disclosed. Obviously, a lot of cases are family violence right from the very off, but there's a number of families that feel much safer to talk about child wellbeing. So in that instance, we're obviously providing support and guidance around what might be available to someone to keep themselves and their children safe, and whether the perpetrator is actually living in the home at the time or is estranged from the family home. We're able to guide and look at what might actually be required, and we often do support with support letters, with actually attending court so that an FEO can be an IVO can be administered, and it's basically down to what does that family need at the time, and we're there to sort of support that journey.
I might just comment on the Escaping Violence program because, obviously we have thousands of people calling around the country for the financial assistance, but part of that program, of course, involves an initial risk assessment, and there's very strong encouragement in that risk assessment for seeking safe practice. So whether that's an intervention order or immediately calling the police, and part of the funding can also be used for things, surveillance and other things that might assist in keeping people safe. So it's very much part of the triaging that happens when people make that initial call. We're assessing eligibility, but that sits right alongside comprehensive risk assessments.
And in terms of supporting people, is it, they may not have dealt with the court system at all yet if they haven't separated and gone down that process. So is it the attending court? Is it the paperwork? I mean, which is the most overwhelming bit that you see? Because we've taken evidence today that where people have English as a second or third language, that the physical filling in of forms can be very challenging. What is your experience?
Well, obviously the adversarial nature of the court system in it is inherently difficult for many people. The other thing is the protracted nature of the court system can exacerbate financial stress. And we remember that for example, if we think about the Escaping Violence program, 70% of people who call are in financial stress already. So that's another element. And I guess it's also the re-traumatising that happens through the family court system. So
there's also a lack of trust and a lack of belief that it will actually make a difference to go through that, and obviously the re-traumatising of what that might actually mean to someone, because there could be a family history there. Often it's very difficult to engage with the legal system because of that lack of trust, and that really it's just down to like an individual person having the strength to go forwards and the encouragement that might be needed to actually carry through with that court case as well, because they've just got no energy and they're just completely trodden down and kind of beaten within a system almost. And so it's actually encouraging people to continue on with that myriad of those reasons for why they should sort of advocate for themselves, and we try and advocate as well alongside of them.
can just add to that quickly. One other commonly cited issue that we see with our clients, and for all the reasons that Uniting have just shared about, the burden or the trepidation with which they then embark upon this process, is that we're still working within a fragmented system. So even just choice of court and understanding the different purposes of the different courts. If it's seeking a family violence order, then it's essentially within the criminal space, and the primary focus is on safety. If it's a family law proceedings, then the primary focus is on the relationship and what's going to happen into the future, and particularly if there are children involved. So there are different purposes and there are different systems, and our clients are, exactly as our colleagues at Uniting said, they're beaten down, they're victim survivors. It takes a huge amount of resourcing internally to cope with that fragmentation. And I think the obligation on us as service providers, on governments, is to remove that burden of fragmentation wherever possible and make it as seamless as possible. And so for that reason, things like collocation and giving the Federal Circuit and Family Court the power to make FVOs would be ways of reducing fragmentation or the burden of that fragmentation.
And so you're really talking about changing both, making changes in both systems, so it doesn't matter which one someone is already in. Are there any other? Is there any other thinking around that in, as far as having support people who know? Like, how would you navigate that for a start, even within the one building, let's say?
I think how you navigate it is one of the biggest questions that we should and probably could be answering, because the answer, it comes in the form of support. I think for too long people have been expected to navigate and carry the burden of the court system themselves or with a lawyer. And with all due respect to lawyers and the role that they play, they don't necessarily have the therapeutic and well-being focus that having support services co-located within the court system can actually bring to that process. So whether it is the FAS that Robin mentioned earlier, the advocacy support services, which have proven to be very successful in the registries where they operate, or other co-located services. I mean, in some states, Relationships Australia works out of the family court registry a day a week, and that's fantastic where the funding's available, because then people have got someone they can talk to that's slightly removed from the trauma of the court process, but understands that process and can therefore guide and make the referrals where they need to be made. I think if we talk about, if we work to break down the legal nature of our courts, knowing that in itself is a really critical feature, but I suppose it's, I'll use that word again, the wraparound services that need to coexist, that would make a huge difference for victim survivors.
In a way, you've sort of given a summary there of the ideal. I'm going to ask the other two groups the same question, but is there anything else you'd like to add to that in terms of leaving us with a message?
No, I think if that's our ideal, I think greater support within that process would just be a really strong outcome.
Uniting, what is of all the things that we could be doing, how would you sum up the real keys?
So the Victorian Marram calls out that court matters, particularly family court proceedings, is one of the situations that's identified in Marram, and I know you spoke about Marram earlier on in the proceedings today, which may imminently impact the victim survivor's level of risk. And our practitioners constantly are calling out the importance of understanding risk as being dynamic and evolving, and that it isn't a static process, and we need to be able to work along a court process with that element of risk at all times, because the risk is it's that real attention to detail. It's how do we respond to that? How do we safety plan? How do we ensure the voice of the child? How do we ensure the necessity around the woman's safety? And how do we support the perpetrator through that journey in ensuring that the violence can stop? You can actually stop that evolving process of family violence, and the violence can stop there. It's just how do we actually do that alongside of the risk and making sure that that voice of the child is really heard within that.
But we do want to affirm, that the Marram framework that has been developed out of the Royal Commission has been, very successful. And it's also, of course, integral to be able to provide that wraparound range of services and supports that help people, obviously navigate what is a fundamentally adversarial and challenging system, but also to move beyond that to, getting healing and wholeness in their lives and being safe and being able to continue to live in that way in our community as they should be able to.
Thank you.
It's that coordinated response to reduce the risk, and we can't do that alone. There has to be multiple systems to navigate through.
Thank you. And Family and Relationship Services, last.
I think that whilst there has been a lot of conversation about the courts, I think that there is a great opportunity for a broader education campaign in the community about the range of services and support systems that are available to them outside of the court system, and that they are more broadly known and more broadly accessed. The siloing nature, both in terms of service delivery systems and the court systems, are unhelpful for people when they are wanting to seek support. So we need to do all that we can to help. I'm not always sure that replicating systems within systems is the best outcome. What we've got to acknowledge is that particular parts of the system do what they do well, and they should be doing it well. If they're not, we need to be working on that. But what we need to have is greater information sharing. We need to have greater information sharing between the services so that they know what each other are doing, so that referral points and that people who are in those once again, that point of engagement is a point of intervention. And everybody should be able to know who within the schematic of interventions that we can provide to families to keep them safe, the children, the victim survivor, the man requiring support as a perpetrator, that we are all well versed in what the opportunities are out there, and that there has to be a better way to help people navigate those systems. Leaving it to themselves to be their own advocate in a very fragmented system is always going to provide harm, risk and gaps that are very difficult for them to navigate. So it needs to be plain English, it needs to be available in many languages and through all sorts of things. So I think that there is a real opportunity for, a broader public awareness campaign about these sorts of things.
Thank you. Dr. Clough, I'm just going to check if there's anything you would like to add.
Look, I will just wanted to add, certainly supporting people to navigate a very complex system is key. And I think, really it's building on what Jackie's just said, actually making sure that the systems understand themselves. So family law system, just give one example, something our members have told us in recent weeks is that what they're seeing more and more, and particularly over the past 3 to 4 years, is, say, the family court ordering parties to family counselling when they are so high risk that putting this couple into a room together for therapeutic purposes is never going to work. Now, I don't think that the court is doing... I think the court's doing that with good intention, so it's really important that between the courts and the family law services that we really understand what particular programs are for, who they're for, when they're appropriate and when they're not. And that comes to really those relationships and the knowledge sharing. And when, our members have also said when you do have that knowledge sharing, say through the Family Law Pathways Network, bringing together judicial officers with family law service providers and private lawyers and whatever, and you get that understanding that that's when it works basically for the kids at the end of the day that are caught up in that system.
Thank you. Thank you all very much for your attendance here today. You'll be sent a copy of the transcript of your evidence and will have an opportunity to request corrections to transcription errors. Please send your responses to any questions taken on notice during this hearing to the Secretariat. Thank you again for your time.
Thank you.
Thank you. Thank you. And I now welcome the National Aboriginal and Torres Strait Islander Women's Alliance to give evidence. We might just pause a moment while our guests in the room manage to escape. Ms. Anders, before I ask you to, I think we're okay. Could I ask you, please, for the Hansard record, to state your full name and the capacity in which you appear before the committee? Thanks, Ms. Anders.
Hello, good afternoon. My name is Wendy Anders. I am the CEO of the National Aboriginal and Torres Strait Islander Women's Alliance. We call ourselves NATSUA for short. And I'm an Arrernte woman from Alice Springs, and I'm coming today to you from Gunditjmaraland.
Thank you very much. Although you're not required to give evidence under oath, this hearing is a legal proceeding of the Parliament and it has the same standings as proceedings of the House. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Do you wish to make an opening statement before we proceed to discussion, Ms. Anders?
Yes, I would just like to give you a little bit of a background of NATSUA, if I may.
Thank you.
We are one of the 6 alliances funded through the PMC to advocate for Aboriginal and Torres Strait Islander women. We are a member-based organisation with over 1,400 members, and we provide our information in our, from our members in all our submissions and everything we do to raise their voice across, the, national and international policy processes. I don't have to tell you that the statistics are very evident about around deaths of Aboriginal women, particularly murdered, given that new report that's just come out, the Murdered and Missing Women report. And we know that the systems don't work and is not working for us. And we believe that there needs to be a major reform and change, and that Aboriginal women should be safe in their homes, safe in their communities. And that First Nation women need to be at the centre of any change or reform. So I'll leave that there and let you ask me questions.
Thank you. We might just introduce ourselves first. I'm Susan Templeman, the chair of the committee and the member for Macquarie and Special Envoy for the Arts. So I'm just in the Blue Mountains and Hawkesbury, just outside Sydney. Deputy Chair?
Thank you, Chair. Good afternoon. My name's Pat Conahan. I am the member for Cowper, which goes from Port Macquarie up to Coffs Harbour on the mid-north coast. I'm also the Shadow Assistant Minister for the Prevention of Family Violence and Social Services. Thank you for coming along.
Hi, I'm Louise Miller-Frost. I'm the member for Boothby, which is Metropolitan Adelaide on Ghana land.
And I might start, Ms Miller-Frost, why don't you start us off?
Thank you. Look, I would start with a fairly broad question. If I could just get you to talk to the committee about the experience of Aboriginal or Torres Strait Islander women who are victims of family violence, going through the family law system, how does that impact the level of violence that they're experiencing, and how does that impact, I guess, their ability and confidence in accessing the services and supports that they need? Sorry, that's a huge question in retrospect. Sorry.
Yes, I will do my best.
The bigger it got.
I will do my best to address some of those questions. Aboriginal women are really reluctant to report violence or to step away from their relationship because of the systems that are in place. They don't have access to services that will provide them the safe, culturally informed trauma support and provide them every service provision they need. We know that Aboriginal women stay in their relationships for their own safety, and that is something that needs to be looked at. It's. I'm trying to think what your question was. It was very broad. It's always an issue when they have to attend court or counselling, anything. There are limited services available to them, especially in some of the rural and remote communities. They have to leave their country to go somewhere else, and there is nowhere else to go. And they shouldn't have to leave their homes and their country to be safe. No woman should have to give up everything just so she can be safe. Did I answer that? I don't know that I did.
Yeah, no, I think that's good. Thank you.
It certainly paints a picture
of
the challenges.
It does. There are a lot of challenges. We're a very diverse group of people, particularly our women. We live in all different areas, and a lot of us live in really remote areas. And for them, the services are just not available. They're just not in the community. They've got to move to bigger centres. And if you look at a place like Alice Springs, there's only one shelter. So, and it's always full. So what do women in the other communities do? They have to go to Adelaide or Darwin or somewhere like that. They're not going to do that. So they're not going to step away from their violent relationship and get help. So that's the starting point. Is there's definitely a need for more services and funding for those services, particularly in rural and remote areas. Which you already know, I'm sure.
Yeah, well, and look, some of this it's just really important to get it into the evidence in Hansard. So, if we're asking you to say something that you think we should know, possibly we do, but it's still important to get it on the record. So, apologise in advance.
No, I do get it.
Look, one of the things that we've heard of earlier today in other evidence was about perpetrator misidentification. And I think your submission identified that this disproportionately affects First Nations women. There is a proposal that these could be extended indefinitely. So rather than being expiring after a year, it would just be an indefinite thing. And the benefit that's been putting forward is then the woman doesn't have to keep going back to court and getting it redone. But the flip side of that is that check and balance. So I'm just wondering if you could talk to where you think that would affect First Nations women, and how does it come out in terms of the balance of risk and benefit from your perspective?
I think we know Aboriginal women are often misrepresented and are charged with assault when they've fought back. It's a difficult situation. I'm trying to think how. I believe that they respond well to people talking to them over time. They need services that will walk through with them. And having an order or something in place for a longer period of time will give them a sense of more security and be able to allow them to find the services they need, find the supports they need, and give them a sense of protection. At the moment, it's not happening. And we have women who are being charged for defending themselves. And Aboriginal women tend to do that more than non-Aboriginal women. They do defend themselves. We know that they often won't talk to the police at the time. They would rather just, particularly if they're really injured. And I think we've stated in our submission an example of a woman who was terribly beaten and just would not talk to the police or anyone else. So she was charged for assault, and that's happening far too often. So there needs to be a lot of training around understanding an Aboriginal woman who's really traumatised and why she won't speak up, why she won't do anything about the situation. And that's having people who are aware of the trauma that these women have experienced in their lives. It's not just a one-off occasion. This has probably been a long-term thing, and she's finally fought back, and here she is now being victimised for it. And I think if she had orders or supports in place for a longer period of time, it may just be the thing that would give her that opportunity to feel safe and to get the support she needs and the help she needs. Is that okay?
Yep.
Absolutely.
Look, your comments around the nervousness or concern about speaking to police, I think feeds into the barriers for women accessing family violence orders. Are there ways that you think that we could work that would make family violence orders perhaps more accessible or more acceptable for Aboriginal and Torres Strait Islander women to... is there a process way we could do that better that wasn't necessarily gatekeeping by police or courts? Is there some other way?
I think there needs to be a lot more Aboriginal police liaison officers who are trained to go to these situations and to be able to speak to the women around what her choices are, what she wants. Often women are terrified of losing their kids, having to move from their family, their supports, so they're not going to participate fully and willingly in anything that's being put to them. They need to have time to think about it, and they need to have people that can actually understand their trauma and be able to talk to them on their own level where they're at, the level where they're at. I don't know what would be a easy way to do that. I mean, certainly a lot more Aboriginal liaison officers with the police, and maybe a team of, some teams of domestic violence, Aboriginal domestic violence workers who can speak to her about these things and support her to get, through the courts and everything else. So, yeah, it's a difficult question, and I'm not sure exactly how we address it.
Thank you. I'm happy to hand. Yep.
Thank you. Deputy Chair.
Thank you, Chair. Thank you so much for your evidence today, Ms Anders. I was a police officer for 12 years and then a criminal defence lawyer for 18 years. I grew up in a township called Kempsey, which has a very high Indigenous population. And you are absolutely correct. There is an underlying distrust of police officers from the Indigenous community, and that's probably as a result of the treatment of Indigenous people over many, many years. One thing that is easily identifiable is that the systems in process at the moment do not even consider the cultural appropriateness of apprehended violence orders or the culture of Indigenous people. And you're 100% correct that there is a lack of training, and I'm not being critical of police officers, even lawyers, there's a lack of training and understanding of Indigenous cultures when it comes to trying to address family and domestic violence. Would you agree with that very long statement of mine?
I absolutely agree with that statement. There is a huge amount of distrust, and it is from years of being, marginalised, and I think we still have a lot of trauma from colonisation. We're still damaged, and people are still not healing. And we need to find a way to heal that trauma, that long-term trauma, and certainly build that confidence in the justice system and the police, and no, you know, it's not always the police fault, but there are incidences when the police don't react in a way that is appropriate, culturally appropriate, are not necessarily, in some cases, yes, racist, but not necessarily because they are racist, because they don't understand.
Yeah.
They don't understand the Aboriginal culture, the ways we behave, the way we act, our community connections. So that all feeds into the trauma of these women when they go to they go to court or anywhere. They're more traumatised because of the system.
So,
and it's a simple thing. Just as an aside, a discussion with other members. We talked about for the Family Law Court Forum. We talked about having courtrooms that were appropriate, like. You look at the boardroom you're sitting in. If you go into a court, you see the judge up there and the people all around. Everyone's got their place. Can we not change that and have a room that is circular? Like a family, so that everyone's connected together around a table, and no hierarchy noticeable.
I was just about to raise that very issue. So the first issue is more education of both the police and the legal system. One program I saw that worked exceptionally well in Kempsey was circle sentencing. And it was exactly how you've described it. It was the offender, the victim, community members, Indigenous community members, the magistrate, all sitting in a room, making the perpetrator or the offender accountable, and listening to how the victim felt and how that impacted on their lives, how it impacted on the community members, etc. There should be no reason why we can't adopt that similar method when it comes to dealing with family violence and family violence orders. So,
exactly. And I'm not just, I might say, with the talk you're talking about Kempsey, I set up the Women's Refuge in Kempsey many, many years ago. And was part of the process of all this. So I'm very, very committed to changing how courtrooms and processes through the courts for Aboriginal women, Aboriginal people. And look, Koori courts are a wonderful thing. We've seen them be effective here in Victoria, and I think that's something else that could be considered. I'm sorry, I interrupted you.
No, not at all. So if we were to take two recommendations out of this, it's better education for the police and for lawyers and even the judiciary, but also alternates in changing the structure of, well, I'll use colonised court process and the process as it is to be more culturally respectful.
Yeah, absolutely.
Great.
And I think that at any system change, Aboriginal women or Aboriginal people have to be at the centre of it. They have to be the ones who are saying, this is what we want, this is what we need. And I think there's a lot of things that are happening that just don't include particularly Aboriginal women's voices. And having a system where it's culturally appropriate, culturally respectful, that's a huge step towards, healing their trauma.
Thank you. Chair?
Yeah, thank you. Thank you for talking all of those issues through. Can I take you to what sounds like it will be a relatively smaller number of women who choose to go who are going through the family law system, family court system, where family violence orders might need to come into play because they're still experiencing violence. and just ask you, in your submission, it makes the note that the separate court system, the family court for parenting orders, the civil court for FVOs and criminal court for FVO breaches, that the time it takes to deal with all those systems also enables systems abuse. And just talk about how that might work better. I just should check your level of concern about the way those systems can allow an escalation of violence, and just get your thoughts on the observations around that.
Yeah, the concern is that these things all take a lot of time, as you say, and during that, the woman is vulnerable. She's, and sometimes orders have run out or haven't been renewed, so she's put in a place while she's waiting for the family law orders to be implemented. She may not be safe, and the perpetrator may have access to her, especially if there's visitation, and the perpetrator has rights to visitation, and we did talk about perhaps, having a video link rather than an actual face-to-face meeting, where the father has a right to still see his children. He can do that, doesn't have to necessarily be in person, and that the woman doesn't have to face him through this process. There's lots of times when during the from one thing to another, civil court, whatever, that she's vulnerable, and that just escalates her trauma and doesn't allow her to feel safe and to make effective decisions. Decisions are made around because of her trauma and her fear and all those things. She needs to have things, in order so that she feels safe right through the process and is able to make informed decisions. But I don't know exactly how you're going to remove all those issues with all the different levels of family court and civil court and whatever. That's a big one.
And that's one of the things we're sort of talking through with people, an idea of some kind of collocation where rather than going physically or logistically to each of the systems, there's a greater integration where it can be dealt with in a single place. Does that sound like something that would minimise some of the complexities?
I really do think it would. If you can all deal with it all in the one place, in the one go, then you're not worrying about the next thing you've got to do, the next thing you've got to do. And women will heal a lot quicker if they're not stressing about what happens next. It's all being dealt with, and it's all, clearly understood, and she knows where she's at, what she's doing and what she has to do, what her responsibilities are, and that allows healing to happen faster. But if you're constantly moving through systems where you can't make informed choices or decisions because you don't know what's going to happen next, no one's going to heal. No woman is going to heal. No one can move on and pick up their life and make change.
How likely do you think it is that there are women in the family court system who everybody would recommend they get a family violence order to protect themselves, but because of the complexity choose not to? How likely is that scenario?
Oh, that's highly likely, and it happens. It happens constantly. We hear it from our women all the time that they won't do anything because there's just no process. It's simple for them. So, yeah, it's highly likely. It does happen.
You've talked about, in the submission, you also talked about that, and you've talked about with the Deputy Chair, the difficulty accessing culturally safe support and legal assistance to obtain a family violence order or to respond to a breach. So if the system was simpler, presumably that would then be the other part of it to mean fewer women fall through the gaps and are left vulnerable. Is that a fair assessment?
Oh, it is a very fair assessment. As you know, there are only 16, I think, Aboriginal legal services. I hope I'm correct in that. And a lot of them are just so overwhelmed that they don't have the capacity to deal with all women. And women are being turned away. Their funding is desperately needed and more services are needed. And services that can work, particularly legal services that can work with these women who have workers that are, and lawyers and have been trained to understand the cultural issues that these women are facing. But I think it's absolutely essential to have more, for women to have more access to legal services that are culturally appropriate.
And just finally, just in case there's anything that we haven't touched on, are there any other ways that it could be easier for Aboriginal and Torres Strait Islander women who are in the family law system to actually obtain a domestic violence order to protect themselves or their children?
Well, having to appear somewhere, to go somewhere to get an order could be made easier if it was done through a video link, or had some other process that where she can stay where she is and apply for it, and not have to go to somewhere where there is a court or whatever, but be able to do it in her community where she's feeling safe, through a video link or whatever other means that technology today is amazing. And I think that would allow a lot more women to actually apply for orders and to actually, feel safe when they're doing it.
And presumably that would also mean that the support can come from someone who they already know and is, as opposed to a stranger in a court system somewhere else.
Yeah. And I mean, it could, if you're looking at, just as an example, that a woman can go online with a magistrate or whoever to get an order, it could be done in health services or Aboriginal controlled organisations with the support workers from those organisations with family domestic violence services. It could be situated in if a woman's in a refuge, she can log in and have the meeting with the magistrate or whoever without having to fear going somewhere or doing anything. And I don't see why that can't happen.
Now, is there anything else that you'd like to add before we conclude? First Nations women need to be central to any change. Yeah. Our voices need to be at the table. And talking to them is the only way we're going to make change. The other thing too is, not to forget that we care about our men and we get really stressed when they're demonised, and that there needs to be more support places and services working with the men to change their behaviour. And there are some really good programs around that actually are doing that. They need to be fully resourced and funded to keep doing, because the only way we're going to change and bring those statistics down is if the perpetrators themselves want to change. And those services need to help them do that.
Sorry, Chair.
Yeah, yes.
And just on that, thank you for raising that, because I was going to ask that question about men's behavioural change programs. I've been to the Northern Territory, far north Queensland, and there are some fantastic Indigenous men's programs up there, and they are they consider culture. So your comments would suggest that the Women's Alliance is 100% behind those types of programs and funding those programs as well.
Oh, absolutely. You know, we are a women's organisation, but we are a family as well and community. So we would support and fully support those sort of services because our men are important and we don't want them to be seen as, just perpetrators because they're not. They're still fathers and husbands and sons and if they can get help and get supported through some of these programs, then, we would support them. Aboriginal women will support them all the way.
Thank you. That's fantastic.
Thank you very much, Ms Anders, and thank you for your attendance here today. You'll be sent a copy of the transcript of your evidence and will have the opportunity to request corrections to transcription errors. If there was anything we discussed that you've said you'll send us, or if there's anything you'd like to add to what you've done, please feel free to send it to the Secretariat. But thank you very much again for being the voice of women, Aboriginal and Torres Strait Islander women for us here today.
Thank you very much for having me, and I hope I have helped a little and made some.
Thank you. It was very, very important evidence for us to hear. And I now declare this public hearing closed.